Please be seated. Good morning, everyone. This is the case of the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. And the attorneys on behalf of Mr. Holmes are Mr. King, Ms. Brady, Ms. Nelson, Ms. Higgs, and Ms. Spengler. On behalf of the people, we have Mr. Brockler, Mr. Orman, Ms. Pearson, Ms. Stitch McGuire, and Mr. Edson. I'm sorry for the delay. I needed more time to rule on D-TR-97, which is the video recording of the defendant at Denver Health Medical Center on November 19th of 2012. And that's a video recording that was completed by two defense investigators as they were questioning Mr. Holmes. I looked at it last night, but I wanted to think about it overnight. I know it's an important issue, and I thought of some things overnight, and I came in this morning and needed more time to look at some things and think about it further, and I've done that. And I'm rather than make a complete record at this time, what I propose is just telling you my ruling and then bringing the jury in so we don't make the jury wait. I have decided to sustain the objection to the exhibit, so the exhibit will not be admitted. Is everyone okay proceeding by having the jury come in and having me make a record later?
Yes, Your Honor.
Mr. King?
Yes, Judge.
Okay, let's do that. Let's bring the jury in, please. Thank you. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Good morning, everyone. How's everyone doing? Good. Thank you for your patience this morning. I appreciate that. At the end of the day yesterday, Mr. Brockler was in the middle of his cross-examination of Dr. Gurr, Dr. Gurr, I remind you that you're still under oath, and Mr. Brockler, you may resume your cross-examination of Dr. Gurr.
Thank you, Your Honor. Good morning, Doctor.
Good morning.
Where we left off yesterday at about 5 o'clock was with the decision to wait 23 months to have a conversation between you and the parents about their son. Do you recall that?
Yes.
Now, one of the things that I wanted to follow up on and ask you is, I understand that your calendar and their calendar, for whatever reason, didn't match up for nearly 2 years. Why not pick up the phone and call them?
Several reasons.
Okay.
The first is that I discussed with the defense team information that relates to early development beyond the records that will be important for me to evaluate, and provided them with questions and topics such as major developmental milestone, when did he walk, when did he talk, early relationships with friends in lower school, relationship within the family, and members of the defense team, the investigator, went out in January of 2013 and obtained information from the parents, including pictures, records, and video that provided me with, at that time, sufficient information on corroborating by school performance and activities of fairly normal early development. And when the opportunity then came up to meet with them, I was planning before to go to California, and it did not work out for me. I prefer to obtain information from parents when available alive, in person, so I can observe them and interact with them while obtaining the information.
Fair to say then that in the choice between talking with them on the phone and asking them the questions and follow-up you thought important based on their answers, and relying upon the attorneys who hired you to provide you with information they thought most important, you chose the latter. Is that fair?
Yes.
And you didn't have any of that information, it sounds like, based on what you just told us, prior to your first meeting with the defendant in December of 2012, right?
Correct.
In fact, you make a note at the end of your handwritten notes for that December 19th, 2012 meeting, and we'll get into detail into that meeting, that you have things to do, and one of them is to contact the mother, father, and sister to get their perceptions of their experiences with the defendant, correct?
Correct. That's the note that we went over yesterday.
Yes. And that doesn't happen then between you and them for an additional 23 months, correct?
But video information is available to me before,
I
and
understand.
pictures of him and school records and description of the parents, to the point that based on the pictures and the description of the investigative team, I was able to identify them in a lobby of a hotel when we met without ever meeting them before. And my interactions with them and the veracity of the information they provided to the investigators was totally consistent. There was nothing surprising, not anything new in what they provided me with.
23 months later, 2 months before we started jury selection, you confirmed that, correct?
Yes.
Okay. Now, the next thing that happens here is in your report of June the 17th, 2013, when you first declared the defendant to be schizophrenic and insane, as you go through, this is what you've numbered as 3. And you'd agree that this is a pretty well organized report, right? You break out the different sections, you label them. One is records, one is background. The next you go through and list the different dates for the interviews. That's pretty well organized, don't you think?
As a neuropsychiatric evaluation report, yes.
Okay. the background that you lay out here, this is before you start to have a conversation with the defendant. Is that fair?
His background?
Well, you list number 3. I'm looking at it in your report, background. All those records and things are things you don't get from the defendant. Those are records you were provided by his attorneys, correct?
Some of the information is provided by the defendant during my interview with him. You know, I established, as I said yesterday, I established a timeline. And the timeline referred obtaining from him information that related when earlier memory that you have, when did you move, how were things at home, what you will start, a comprehensive evaluation based on the information that is provided. It is not information just provided by the defendant,
now,
by the defense team.
Now, Doctor, I understand what you're saying. Those portions, though, of what he told you about his background, you have included specifically and with reference to him in each of the dates that you interview him in your report, correct?
Correct.
So everything under background, and I'll begin with your first sentence, the records indicate. Everything in that first section is established by the records, correct?
Yes.
Okay, that was my question. And those records were records that were provided to you by the defense team, fair?
Birth records?
No, just the, Doctor, the records that you include under
Yes.
background, correct?
Yes.
Is that yes?
Yes.
Thank you. One of the things that you do is you start to try to establish, as you said, a timeline, and that timeline really is a narrative. You'd agree with that? Is this in a narrative form, Doctor?
Yes.
Okay.
I mean, what I summarize here, yes, is in a narrative form, yes.
Okay. And in going through those records, you lay out the things that you think are going to be relevant and helpful to explaining what mental health or psychiatric situation or changes the defendant is going through over the course of his life, correct?
Yes.
First thing that you do as you go through this, you talk about that his mother noted that he had limited verbal output at an early age, correct?
Yes.
That really doesn't change throughout the course of his life. You'd agree with that?
Not quite. I know you want me to answer with one word. It's hard for me, I think, to answer with one word.
Well, maybe the one-word answer is no, that it did change. And if that's your answer, then I'd ask you.
Yes.
Okay, tell me.
So earlier in development, one of the questions that I've asked the defense to obtain from the mother was, when did he begin to talk? And there's variability in children about language. Boys many times speak later than girls. Girls are more fluent. And commonly you expect kids to begin to talk in sentences, 2 words, 3 words, 4 words, age 2, about. There's variability again. And I wanted to know if he had some difficulty earlier on in talking, in verbalization. And the information was that he did have some difficulties. By age 2, he was talking as expected. And the difficulties that I inquired specifically and got back information was that at times there will be just few words that he will say, and his maternal grandmother, his mother consulted with his maternal grandmother who advised her, when you are with him, why won't you point at objects around the house, and this will facilitate him learning about furniture and things like that. So by age 2, he was okay. And that was what the information that I got, and I confirmed in future interview directly.
Thank you. The next thing that you go through is you talk real briefly about a situation where he'd had some outbursts at home, correctly?
Correct.
Correct, sorry. And then the next big thing is when you reference the counseling that has to take place after they move back from Salinas or Castroville up north down to San Diego. Do you recall that?
Yes,
And that's significant because that's a big turning point as you see it in his background, correct?
yes,
And really, prior to that, there were no documented issues of him being introverted or socialization or hooked on computer games. There's nothing like that. It really begins with this move to San Diego, correct?
correct.
That outburst thing that you talked about, let's just step back there. That's when he was 8, is that right?
Yes,
Do you remember the outburst?
yes, that he will stay more in his room. He will disagree with his parents on things that he needed to do, and his parents thought professional help. He saw a social worker who advised his parent, or interacted with him. I believe it was in an outdoor setting that many times professionals adapt to children, and worked with the parent. There was a limited number of sessions, advised the parents of how to approach him. He was firstborn, less experience with children, that the parents had, and it resolved, easily resolved.
Understood. The outburst that you documented later on was that you said he had barricaded himself in his room, correct?
Yes,
And you remember, too, that you were able to obtain the records from the Family Services Agency of the Monterey Peninsula where this counseling took place, right?
Yes.
They were given to you by the defense attorneys, correct?
yes,
And you received those prior to writing your report in June of 2013, correct?
yes,
And what the specific notes in that say has nothing to do with being barricaded in his room, correct? Do you recall? If you don't recall, ma'am, you can say, I don't remember.
I don't remember.
If you don't remember, we'll move on, and then if there's something else, you'll be able to add it
Okay.
in, I'm sure.
Okay,
What the records actually reveal is that the concerns from the parents, based on their history, was that he was nonverbal. Do you recall that?
yes,
That he was Nintendo-oriented. Do you recall that?
yes,
That he had poor socialization. Do you recall that?
yes,
And that he had introversion behavior, correct?
yes,
These were things that existed as part of who he was even at age 8, correct?
yes,
And the behavior he engaged in was to throw toys, correct?
yes,
There's observations that the social worker makes that you noted, not in your report, but that you'll remember, where she's observing him interacting with his family on a walk to the park, correct?
yes,
And one of the things she says is, look, he's completely mute, right? You remember that? He's mute.
I don't remember that.
That he's, his head is kind of askew or cocked to the side. Remember that?
Yes,
And that she's not sure he's paying attention, but he observes every single pedestrian and traffic signal on the way to the park. Do you remember that?
yes,
None of that, none of it, is documented in your report of June of 2013. Do you agree?
yes,
And they actually, at the time, through their billing records and whatever, I don't know if diagnosis is the right term, but their conclusion is he has oppositional defiant disorder, correct?
yes,
Now, before we get back to the psychiatric history part, you go through sort of the rest of his schooling, where he went to school, the middle school, the high school, and the fact that he ends up graduating from Riverside, and he applies to 8 graduate schools in neuroscience and was not accepted. Do you recall that?
yes.
One of the things that's not detailed in there, and it doesn't look like you follow up with him on this, is how many of those schools did he have interviews with? Do you remember?
I remember that he had an interview at the University of Iowa, I believe, and I think he had maybe one more interview, but I'm not sure.
And doctor, I know that because there's 2 rounds of this, you may be thinking of that second round of interviews that led him to see you. Is that fair? You may be thinking about that interview at Iowa and at CU.
Iowa was the second.
Yeah. So just so that we're clear, and I don't want to confuse you. He graduates from Riverside. Great grades, honors grad, all that, right?
Yes.
He applies to 8 graduate schools, correct?
Yes.
He doesn't get into any of them, correct?
Yes.
And then he spends a year living at home, correct?
Yes.
He reapplies to a couple, including Iowa and CU, that second time, correct?
Yes.
So are we on track now?
Yes.
Okay, what I want to ask you is, that first round of interviews where he is on paper, this guy is a superstar, he applies to 8 graduate schools. Do you know how many of them granted him even an interview?
As far as I remember, none, but I'm not 100% sure.
So in your recollection, he is rejected outright off of just his application, nothing to do with his interviewing, from 8 different neuroscience graduate programs, correct?
Yes.
That's got to be a blow to the ego, correct?
It can be.
Yeah, especially for a guy who has said, this is my life's goal. I want to be a neuroscientist, correct?
Yes.
So he goes home and he lives at home, right?
Yes.
And he gets into playing video games again, right?
Yes.
In fact, frankly, based on all the records you've reviewed and your interviews with him, he never stops playing video games. From that first time you see him as Nintendo-oriented on paper at age 8, he's always playing video games, right?
Yes.
And at home, with nothing to do after being rejected from 8 schools, he plays a lot more video games, right?
Yes.
And doesn't do much else around the house, correct?
Yes.
Creates tension with mom and dad, right?
Yes.
Mom and dad start browbeating him into getting a job, right?
Yes.
And what he does is he ends up applying to a temporary agency, right?
Yes.
And that temporary agency goes out and finds him the job at the pill coating factory, correct?
Correct.
All of those details that we just went through, outside of applying to 8 schools and being rejected, none of them appear in your report. Fair?
They're not detailed, but they're referenced in the report that he applied to school.
And then the next,
as we noted before, my report is brief, and it was not my intention to provide every specific information. It was too voluminous.
it would have been too much effort to write a report that long. Is that right?
Not effort, it's just something that is not a standard way in providing a neuropsychiatric report.
In a clinical setting?
In a clinical setting.
Okay. You knew you were writing this, though, for the courts, right? Correct?
That it might be presented in a court, yes.
Well, you knew you were presenting it to attorneys, right?
Yes.
You knew that those attorneys were going to use it in a criminal case where someone was accused of 160 plus counts of murder and attempted murder, right?
Yes.
Knowing all that, though, you wrote the same report you'd have written if this guy had walked in off the street in your clinic, correct?
Based on more observation, more hours of interviewing, and knowing that the information that you have described is something that I've looked at, reviewed, and is available to be presented in the court.
So the answer is yes, same clinical kind of report, just you had access to a little more information, correct? Yes?
I'll say a lot more information.
A lot more information. And that lot more information resulted in a report that you generated that was 15 pages long, correct?
I take your word for it. Yes.
Yeah, and that 15th page is really just your signature underneath a paragraph that describes who you are, correct?
Yes.
The first couple pages are just a listing of records you've reviewed, and you start to get into some of the background, correct?
Yes.
And in terms of the actual report writing based on the interviews you did with the defendant, that makes up, 35, 40% of the report. Is that fair?
About, yes.
Now, one of the things you did when you went through this timeline that you made is you put into your report that he got through undergraduate school with pretty much A's, and A pluses for his grades. Do you remember that?
Yes.
And you know that because you went through his transcript, correct? And you saw
Correct.
that. And in going through his transcript, one of the things that you saw was that right before he graduates, he gets an A in a class called Ethics and the Meaning of Life. You remember that?
Yes.
And Ethics and the Meaning of Life, and by the way, records that are contained in the discovery here, which, and by the way, am I wrong when you said you reviewed about 100,000 pages worth of stuff?
Lots of stuff, yes.
One of the things that's in there is the syllabus from that class. Do you recall that?
I do not remember the syllabus from that class.
So not remembering the syllabus probably means what you didn't do was look to see what the philosophers and the writings he was required to read and master to get an A. So you didn't consider that, right?
No, I knew that there were readings that had to be done to the class, but I cannot recite the readings for you.
Right, and you didn't go into the details of them to see specifically, is what he's studying right before he graduates, what he's mastered with an A, is that consistent with what he wrote in the notebook? You didn't check that, did you?
I know that in the notebook, some of the philosophical statements and his writing are based upon his reading. We did discuss his past reading that related to philosophy and that are based on it, but I did not go back and check page by page how does this writing relate to the syllabus or to his academic writing. I did not.
Doctor, that conversation that you've just testified to, that we haven't heard you testify to on direct exam, the one where you asked him about the books that he was reading that helped him generate these philosophical writings in his notebook. You didn't have that conversation with him before June of 2013 when you opined that he was schizophrenic and insane, did you?
Not in detail, that followed later.
When you say not in detail, can you point to me anywhere in your notes or report where you even reference it in general that you had that conversation with him?
I think that on the notebook that I began, to see, that I began to go over with him on May 2nd visit. What I did first is go over the notebook in general and asking him about his philosophical approaches. But if you ask me, did I write down every answer or every question that I asked, the answer is no, I did not.
Well, and you didn't even write down that subject matter in your notes or in your report, correct?
Correct.
So what we're hearing is you are remembering today, July the 8th, 2015, a conversation that you purported to have with him on May 2nd, 2013. Is that right?
Yes.
Okay. One of the other things that you indicated in your report that you seem to emphasize as significant was that the defendant, and this is before you talked to him, this is in the background part, that he performed below expectations in his graduate level work. Do you recall that?
Yes.
And when you say below expectations, you are talking about in the abstract, just on paper, aren't you?
May I ask you to clarify, please?
Yeah, when you say he performed below expectations, here's why I'm asking that. Mm-hmm. We had a bunch of professors from that neuroscience program come up here and tell us it's just not that unusual for people who are great students on paper in undergrad to come here and not succeed. You don't disagree that that's true not just in neuroscience, but in everything, right?
I agree, and I said that yesterday in my testimony.
I understand. But in your report, what you said is he performed below expectations, right?
Correct.
You also then have quotes in this section that are not attributed to any specific individual. And I'll point you to them. You said Mr. Holmes was described as disorganized in his answers, seemed to wander around. He didn't give clear answers, was trying to answer, but not being clear. Who said that?
Can you please let me know what page are you on?
Oh, ma'am, I've kind of cut and pasted it from your report. It should be under that background part, and
But
which
I remember the words, so it's
okay.
okay. I
Okay,
remember the
thank you.
words. So this was information that was obtained. Two points. One was from his description of his difficulties in graduate school, and by the defense team interviewing people who knew him and people who were part of the lab in graduate school.
So, and to be clear though, it wasn't important for your purpose, and that may be the case, to indicate who said that about him, whether it was a fellow student, a professor, a friend, a girlfriend. It's just a quote you throw in there. Mr. Holmes was described as, correct?
Correct. I did not put a specific name. I think that these are probably available in the information that was obtained and might be available to you too.
We may just not have heard from those particular witnesses in this case, right?
Possibly.
Now, the other thing that you said in here is that he did not do well uniformly, not specific to a section. Do you recall that?
I do not remember that, and I will have to look at the context of the report. I do not remember these words.
I think it's in that background part there. It might be part of that same paragraph. Yeah.
Yeah, I see it.
Okay.
I see it under, yes, I see
Okay,
it.
so you described him as not doing well uniformly. Do you recall that?
Yes,
Truth is, guy did well in almost all the classes that required just writing, didn't he?
yeah, he got good grades.
Yeah, got good grades in grad school. So when you say he did not do well uniformly, that's not really borne out by his performance throughout both semesters of grad school, correct?
Yes and no.
Well, what's the no part? Where is it uniformly he didn't do well?
The no part, the no part is his expectations from himself. He considered his performance to be below what he wished to perform and excel in graduate school. His perception that was not, as I said yesterday, was not consistent with the grades and the perception of his professors. He might have had some difficulties in a laboratory in performance requiring going over the procedures, which can happen in graduate school. His perception was that he is a failure. That's the irrational part about him.
Doctor, that statement that we just agreed that you made, he did not do well uniformly, not specific to a section, that is contained in a paragraph that is not from the defendant. It is about the defendant from information you were provided by defense attorneys, correct?
From information from him.
In that section?
From interviewing him, yes.
You don't put quotes around anything in there, nor do you use the phrase, Mr. Holmes told me he did not do well uniformly. Do you agree with that?
Correct. These are not his words. It's my summary of the words that follow up later.
In the background section before you ever sit down to talk with him, correct?
The background section was written after I interviewed him several times. So part of the background information is the information I obtained from Mr. Holmes. It's multiple sources. It's school records, interviews of students and lab directors who worked with him, and information obtained from him, all the information that I could obtain.
Doctor, I think we've sort of missed something about that quote. There actually is quotes around that sentence, he did not do well uniformly, not specific to a section. Do you see that? There's an end quote there, right after not specific to a section. You put it in there. Do you see it?
Yeah, I see it. It started, it didn't give
Right.
clear answers. Yes.
So let's read the whole quote.
Okay?
He didn't give clear answers, was trying to answer, comma, but not being clear. Gave much less detail than should have been given. Answers were not coming out. He did not do well uniformly, not specific to a section, end quote. You agree?
Yes.
That did not come from the defendant, right?
I do not remember if these were his words that I put in or words of other people.
You think that this quote where he could be describing himself in the third person, he didn't give clear answers, he could have been talking about himself?
Possibly, yes.
Is there any time, anywhere, on any piece of paper, report, or otherwise, you indicate the defendant refers to himself in the third person?
No, but I refer to him as he.
But you put the he in the quotes, right? Like someone else is describing the defendant. Correct?
I mean, for the grammatics in English, it might be that this is the case. It is not my first language, and sometimes I just might make a mistake in how I write, and for this I apologize. But I do stand that this information was obtained both from the defendant and from other people who were interviewed by the defense. It doesn't take away from the veracity of the information.
Understood.
Maybe I didn't use the quotes properly, for which I apologize.
Well, that may be a different issue. We'll get to the quotes part in a minute. But to be clear, nowhere in any report do you attribute this statement or even these kinds of words to the defendant. Agreed?
Yes.
In fact, it is equally plausible that this was a statement or a quote given to you by the defense attorneys that you adopted and put in your report, right?
Possible that it was in the information of the interviews that Dave conducted with his peers and instructors in graduate school.
Okay. Then there's a section under social history that again has a number of quotes in it, but they're not attributed to any individual. Do you agree with that?
Yes.
You don't document who said them or what their relationship was to the defendant or how it is they may even know this, right?
Correct.
You then talk about, briefly in this social history, you indicate that he was asked out on a date in October of 2011. Do you recall that?
Yes.
Is it significant who asked whom out or who initiated that relationship?
Not necessarily. At times, females will be more straightforward and ask a male for a date. And at times, maybe more common is that a male will ask a female for a date. But there are females who ask for a date.
But in this particular situation, we're talking about a guy who has had introversion issues and socialization issues starting at age 8. You'd agree, right? Yes?
Well, I think that the degree, if I may answer in more words, I think that the degree, there is always a process, a developmental process that can be signs before that a child is shy and not seeking out interactions with others, but the child is within normal limits. There are many children who are more shy. It is becoming more noticeable, is what I try to document, is after the transition to San Diego. So to put it at age 8, they sought professional help, and this was observed, but it did not seem to have such a marked impact on his life at this young age.
And I get what you're trying to add in there, but let me just be clear for the record.
Yeah.
These weren't just things that were observed. The statements about Nintendo-oriented, poor socialization per mother and father, and the introversion issues, introvertive behavior, were all things that his parents told the social worker when he was age 8, correct?
Yes.
Okay. So in this case, though, we're not talking about a guy who's like any other guy, boys ask out girls, girls ask out boys. We're not talking about that, right? Correct?
Partly, yeah.
Well,
I mean,
and again, in part because you described him as being somewhat of a loner even in undergrad, right?
yes,
Okay. So in this particular case, though, what you remember is the defendant reaches out to Miss Dada through a CU email. Do you remember that? To get her phone number? Does that help?
that's in his undergraduate.
No, ma'am.
No, you're talking about graduate school?
The only girlfriend he's ever had in his life.
To Gargi.
Yeah.
Yes, yeah,
So you recall that he reaches out to her by email to get her phone number, correct?
yes.
And do you remember the clever little thing that he put in the email to get that?
I don't remember.
Do you remember something along the lines of, hey girl, I lost my phone number, can I get yours?
Yes,
Yeah, that's kind of clever, isn't it?
yeah.
Then you say, and there's not a lot more of a discussion here, you describe it as he was asked on a date and had his first and only girlfriend. She stopped the relationship, and then you move on to other stuff. Do you see that?
Yes,
Okay. And then you highlight in there, you say by early April 2012, he cut off almost all relationships with other graduate students and became increasingly isolated, right?
yes,
And you thought that that was significant.
yes,
One of the things, though, that is not referenced in here are his efforts to initiate a dating relationship with another woman from his graduate school program, right?
Hillary?
Correct.
Yes,
And not only is it not documented here in your June 2013 report declaring him schizophrenic and insane, it's not documented in any report that you generated, is it?
correct. I did not document all email exchanges and interactions with people in the graduate program.
This is a relationship that he initiated in mid-April, correct?
Correct.
And continued on, including texting conversations back and forth through early July, right?
Yes,
And it appears nowhere in any report or any notes that you generated. Is that fair?
yes,
So when Mr. King approached yesterday, Your Honor, may I approach?
Yes.
And got you to say, yep, I looked at these texts and I considered these texts and I thought this language was significant. Do you remember all that?
yes,
And I'm talking about People's 1046. Whatever significance it had wasn't a big enough deal to put in any reports that you thought judges, attorneys, or a jury might review. Fair? Fair?
in my report?
Yeah.
Yeah,
Okay. It's not in there, right?
no,
We'll get to some other stuff that he did regarding his attempts at socialization as he leads up to the shooting here in a bit. But I want to keep going through the flow of your report here, this initial report declaring him insane. You go through, now we're in the psychiatric history again. Remember that?
yes,
We've already covered age 8, right?
yes,
And in fact, this is the section under psychiatric history where you write temper tantrums and barricading himself in his room, correct?
yes,
And because those were not contained in the actual reports from the Family Services Center, you had to have gotten them from either the defendant or his attorneys, correct?
yes,
One of the things that was important to document was that this suicidal gesture of scratching his wrist with cardboard. Do you remember that?
yes,
Now, that is not documented in any medical records that you were provided prior to meeting with the defendant. Fair?
correct.
And the parents certainly didn't know anything about this, right?
Yes,
Because the defendant only did it in the van, yes,
yes,
where no one could see it, correct?
yes,
In a manner where it couldn't really cause any damage, correct?
yes,
And so that it wouldn't be visible to others, right?
yes,
And then he kept it from everyone else around him, right?
Yes.
So that suicidal gesture could not have been the precipitating factor for him going to see Mel Lipsy after they moved to San Diego, right?
Yes.
You were told by the defense that the parents had observed this suicidal gesture?
Objection calls for hearsay.
Why don't you rephrase your question?
Ma'am, you were provided information by the defense from whatever source that you considered in your expert evaluation here that his parents actually did know about the suicidal gesture, right?
No.
You were never told that. Is that right? Is that true?
Yeah.
You were never told that.
Yeah, in the paragraph on page 3, when the family moved back to San Diego, the parents were concerned about his increased isolation, lack of interaction with other children, and the suicidal gesture of scratching his wrist.
So it sounds like the parents knew about the suicidal gesture.
The parents did not know about it.
So when you write the parents were concerned about isolation, interactions, and the suicidal gesture, how could they have been concerned about it and not have known about it?
No, so it's out of place.
It's not accurate.
It's not accurate. They did not know about that.
Okay. Okay. So they ended up going to see Mel Lipsy then just for, it looks like, unless there's something else inaccurate about this, just about their concern about his isolation and lack of interactions, right?
Correct.
We'll get to another possible reason for that, but I want to get back to the suicidal gesture. Do you remember that the suicidal gesture that you've described that he made that was unknown to his parents, that it was because he did not want to move back to San Diego, right?
Yes.
He had friends up north, correct?
Yes.
He did not, and we already know social anxiety, big deal for this guy, right? Is that true?
Big deal.
Yeah,
at
big
that time,
impact on his life.
Before departure, yes.
Yeah. So that's why he tried to make that suicidal gesture as you've described it with the cardboard, correct?
Yes.
Something else you put later on in your report that you said the defendant told you was that he did it because his parents told him not to speak. Do you recall that?
Yes.
That's not in this section, is it?
No, it's not in this section, it's in another section.
And being told not to speak feels different than I just didn't want to move because of my friends, right? Correct?
It's one component. There are multiple components to he didn't want to move. There are multiple components for him being upset. One is the move, and one is his explanation that his parents don't want him to talk.
So when a guy tells you, when the defendant tells you at some point, any point, whether it's now or 2 months before we start jury selection, that part of the reason he made this first and only suicidal gesture in his life at this pivotal point, that he did it because people told him not to talk, you want to look into what that means, right? Correct?
Yeah.
Okay. You never asked the parents what that meant, did you?
I did talk to them about, they did not remember that they asked him not to talk. I did go over it with them when I met them later on.
So they don't know what he was talking about, right?
Correct.
And what your report and your notes reveal too is that you did no follow-up with the defendant himself about what it meant people told him not to speak. You don't have any explanation for that anywhere in your notes or your report.
I did talk to him about it, and my understanding of it, my clinical interpretation of it, is that he was justifying at multiple levels the difficulty that he was having. And rather than say, I have difficulties at that time of talking to people, interacting with others, is that I'm told not to talk. That's why I am so different. Not a logical explanation, but that's what was my conclusion.
The other stuff, though, your clinical impressions and interpretation, none of that found its way into your notes or your reports. Fair?
Yes.
Okay. So we're hearing that for the first time right here today on July 8th, correct?
No, but I wrote it down that he told him not to talk.
But just that, right?
Yes, yes.
Okay. Now, one of the things about going to see Mel Lipsy, it was because of this socialization issue, and I'm sorry, there was one other thing I left out. Socialization and what was the other thing? Can't remember.
And lack of interaction with other children.
That's it. One of the things that was not a precipitating factor was information that was revealed to you that he had backhanded his sister or been violent with her in any way, right?
No, he had difficulties with his sister at home.
Doctor, what I'm asking you is, you don't have any described connection, or in fact, you don't ever say that he was physically violent with his sister in here, right?
Correct.
And you don't associate him backhanding his sister with the parents' decision to take him to see Mel Lipsy as part of family therapy, right?
Not at that time.
Right. The reason I ask this is there's a guy named Dr. Jonathan Woodcock. Have you heard that name before?
Yes, I did.
Okay. And prior to meeting with the defendant, December, February, and May, and then writing a report opining that the defendant was insane and schizophrenic, did you have Dr. Woodcock's notes?
I did see his notes, but I'm not sure what was the date that I got them. I can check it.
Do you think it's possible that the defense did not give you Jonathan Woodcock's notes until after you had opined that the defendant was insane?
Objection. The counsel's making us a witness.
Go ahead, doctor.
Yeah, I don't remember when I got Dr. Woodcock's notes.
Now, and we'll get into some more of the things that was told to him, but he has a pretty unique vantage point of the defendant, doesn't he?
I'm not sure what you refer to.
And I'll clarify that.
Okay.
He is a psychiatrist, right?
Yes.
And he's actually a board-certified psychiatrist, right?
Yes.
And he saw the defendant in jail 4 days after he went into that theater to kill all those people, right?
Yes.
So his notes and his observations would be something you would want to have if you're going to try to evaluate what was going on in the defendant's head 4 days earlier, right?
Yes.
You don't have any notes or any documentation anywhere before you opine that the defendant is schizophrenic insane about a single thing that Dr. Jonathan Woodcock did or got from the defendant. Is that fair?
I knew that Dr. Woodcock interviewed the defendant for about 3 hours and thought that he was psychotic, mentally ill and psychotic, but I do not remember when did I get his notes. But I did know that he did interview him, and this was the diagnosis.
Did you know that he
considered.
I'm sorry, doctor. I'm sorry. Did you know that he'd interviewed him before you opined that he was schizophrenic and insane?
Yes.
Okay, so knowing that he interviewed him, one of the things that would have been critical to you is to have a conversation with Dr. Woodcock, right?
Yes.
You did not do that.
I tried.
You did not have a conversation with
I
Dr.
did not
Woodcock.
have a conversation.
And we've heard he's not good at returning calls. Is that what happened?
I did not get a call, correct.
There's also 14 pages of notes that you must have been aware he had taken some notes from this meeting, right?
Yes.
And before you issued a report opining to the attorneys and to the court that this guy was insane and schizophrenic, you must have insisted on seeing those pivotal notes from 4 days after the crime, right?
And I'm not sure that I did not see them. I said I do not remember when I had the notes.
And
so this is something that I can check into.
Yeah, well, and part of it, though, is because it's not documented anywhere in your report, right?
Well, in the background information, it does say that I've reviewed medical, psychiatric, other institutional records and relevant portion of the discovery material related to Dr. Holmes. And it might be related to Mr. Holmes that have been created. I believe this was part of it, but I do not enumerate, as we have gone through before, all the records and day by day that I've seen that maybe is the standard of a forensic report, but not of a neuropsychiatric report.
But to be clear, one of the things that you do, doctor, is to make sure that, and I'm sorry I said do, but that you do engage in, is to put in your reports those things that you believe are significant and important to your conclusions and evaluation, right?
Yes.
And not a single word or reference to Dr. Woodcock appears anywhere in that June 2013 report. Fair?
Yes.
And the reason that's important, doctor, is because, and you've probably had a chance now to review those records, is because the defendant tells Dr. Woodcock on July the 24th that the reason they had to go to family therapy was because his parents were concerned when he backhanded his sister. Do you recall that?
Yes.
That is inconsistent with the statements he made to you about why they went to see Mel Lipsy, correct?
I knew that he had difficulties at home with his sister, and it was provided by him. I did not include it in putting it down at the report.
And doctor, what we can conclude then is that you certainly didn't talk to the defendant at all about any physically aggressive anythings that the defendant did with his sister as a predicate to going to see Mel Lipsy, right?
Not as a predicate of going to see Lipsy, but in covering his relationship at home with his mother, his father, and his sister. He had no relationship, a good relationship with his sister.
You know, I understand. I see that in your report, but nowhere in your June 2013 report opining on schizophrenia and sanity do you go into anything with the defendant about physically striking his sister. Fair?
Yes.
And nowhere in that report does it indicate that the reason they went to go see Mel Lipsy had anything to do with acts of physical confrontation between the defendant and his sister, right?
As a third component to the social isolation and the other points that you went through.
Yeah, I understand. Then we go through some more of the details of the psychiatric history
Yes.
that you think are relevant enough to include. Fair?
Yes.
One of the things that you include in there is a reference to his trips to see Miss Roth, Dr. Fenton, and Dr. Feinstein, correct?
Yes.
And you type in not all of the notes that they generated, but just some notes that you thought were most relevant, correct?
Yes.
One of the things that you did not do prior to opining on sanity and schizophrenia was you did not pick up the phone and speak with Miss Roth, correct?
I did not, and my understanding from the defense was that they are not available to talk to us, all of the people, all of the professionals who have seen him, that this is not an avenue that I can pursue.
Understood. That means, too, then, my guess is you didn't reach out to Drs. Fenton or Feinstein.
On legal advice.
Right.
I mean,
Understood.
I cannot just pick up the phone and call people.
I get that.
Objection, may we approach?
Yes. You may proceed.
Doctor, one of the things you indicated in the section where you start to go through some of the notes that Miss Roth indicated here was you end up at some point saying that the defendant went to go see Miss Roth and Dr. Fenton and Dr. Feinstein to rid himself of his homicidal thoughts. Do you recall that?
Yes.
Again, back to Dr. Woodcock's notes. You recall from Dr. Woodcock's notes 4 days after this shooting what the defendant told Dr. Woodcock about that.
Related to anxiety? You
No,
mean?
related to why he sought treatment and his thoughts about the homicidal ideation. Do you recall that?
I don't remember. I remember he spoke to him, but I don't remember the words he told him.
You remember in the notes that the defendant says, I didn't really consider them a problem.
Yes.
That statement did not make it into your report. Fair? Is that fair?
It is not in my report.
One of the things that I just want to make sure that I'm clear because someone told me they didn't think it was clear, was that he did not consider his homicidal ideations a problem when he spoke about them to Dr. Woodcock 4 days later pursuant to his notes, correct?
He did not disclose to Dr. Woodcock that this was a problem.
It's more than that, actually. Doctor, do you remember in the notes, he actually is asked by Dr. Woodcock, and Dr. Woodcock asks him, and the defendant says, I didn't consider them a problem. You remember that?
Yeah, that's what he reported.
Okay. One of the other things that is not indicated in the notes here, I'm sorry, it is indicated in the notes, but it's important, is that he denies any suicidal ideation to Miss Roth, correct?
Correct.
And it's your understanding that throughout the course of whatever treatment he allows himself to go through with Dr. Fenton and Feinstein, he denies suicidal ideation every single time, correct?
Yes.
In fact, what he tells them when they ask about his past history of suicide or suicidal ideation, he denies that too, correct?
Yes.
He also denies being depressed, correct?
Yes.
Start to stop from March through June, fair?
Yes.
And he's never observed by any of them to be depressed, correct?
It's not in their notes.
Well, yeah, and in fact, they say he doesn't seem depressed in their notes, right?
Yes.
So it is in their notes, right?
I'm sorry, what I meant is that it's not in their note that he is depressed. They do not see depression.
Correct. They noted that he did
He's
not
not
seem
depressed.
depressed to them.
Yes, correct.
One of the things that you indicate in here are that he is on a certain amount of medications, right? Correct.
Yes.
One of the things that I don't see at any time in your interviews with him before you opine that he's insane and schizophrenic in June of 2013 is a conversation you had with the defendant where you asked him why he stopped taking his medications in May. You recall that? Did you ask him anything like that?
Yeah.
You did?
I discussed it with him.
You discussed him discontinuing on his own his medications in May of 2012?
Yeah.
Where is that?
It's not, as you know, as I said before, my report does not include every word that I exchanged with Mr. Holmes. It was difficult to conduct the interview. It was important for me to obtain as much information as I could and pay attention to him and encourage him to talk more. But I did go over with him his student health experience, the medication, the effect of the medication on him, and discontinuing treatment on his own. Treatment was available to him, as we discussed, and with that, discontinuation of the medication. He discontinued treatment.
Right. He discontinued treatment after the June 11th appointment with Drs. Fenton and Feinstein, correct?
Correct.
But he discontinued taking his medications as early as May. Do you recall that?
Yes.
Okay. And again, it's not in here because you didn't think that decision by him to discontinue his medications was significant to be considered with your opinion about his sanity or his potential schizophrenia. Is that fair?
I thought that in the total picture, based on all the information, is discontinuing the medication was not something surprising. Most people, many people do that, as you were mentioning yesterday yourself. 50% of people with schizophrenia go off and on the medication. This is common, lack of adherence, well documented in the literature. So I did not think that this was the most important part leading to what happened on July 20th.
So that we're clear, even though you think it's consistent with schizophrenics, as you've just told us now, it wasn't important enough to document in the report.
I did not consider that I need to document it in the report.
And in fact,
when asked, I'm telling you.
Thank you. And in the absence of the notes and the reports, you're actually recalling that for the first time here on July 8th from a conversation you had perhaps more than 2 years ago, right?
Yes, but it is a standard of conducting an evaluation that relates to the care provided, the medication. Did you stop? Why did you stop? It's so.
Here's why I'm asking is that you go through details of the medications he's prescribed in several paragraphs in your report. You agree with that, right?
Yes.
Because it was important to detail the medications he was on, correct?
Yes.
And you even detail the dates that those prescriptions were made, correct?
Yes.
But what you're telling us here today is it was not significant enough to document that he chose to discontinue them in May before he discontinued his treatment with Drs. Fenton and Feinstein.
Objection, misstates the evidence.
Overruled.
Go ahead, doctor.
So I did not document it in my report.
Okay. Now, in your, you go through this analysis then, paragraphs of stuff that takes place with Ms. Roth, Drs. Fenton, and Drs. Feinstein, and you get all the way up to that last meeting in June of 2012 in your report. You agree with that, right?
Yes.
And then the next thing you write about in the psychiatric history are the events in November of 2012. Do you agree with that?
Yes.
And in between there was that pivotal 2 hours and 45-minute interview with Dr. Woodcock 4 days after the shooting, right?
Yes.
That is a visit by a psychiatrist, correct?
Yes.
Where he is taking in part some psychiatric history, right?
Yes.
Even though he told us he wasn't allowed to talk about the crime or any of the planning for it. You remember that?
Yes.
That appears nowhere in your psychiatric history delineation in your report, correct?
Correct.
Now, there's only a couple reasons that could be, and I want you to tell me which one it is. One, I didn't have the information at the time, otherwise I'd have put it in there. Or, I read through it, I saw it, didn't think it was that big a deal, and that's why I didn't put it in there. Which one?
I don't remember if it was the first, if I did have the report before, and I can check.
So that, I guess that explains then, you'd agree, why in your report and in your interviews you never discuss with the defendant anything about plans A, B, or C, right? Do you even know what I'm talking about?
I know what you're talking about, and I did go over it with him later about his plans.
I get it, but I'm talking about plans A, B, or C. You don't go through those with him before you opine that he's schizophrenic and insane of June of 2013, right?
Not in the order of plan A, B, or C, but focusing on his state of mind and the alternative that he considered before that.
And you don't put in anywhere in here the statements that he made to Dr. Woodcock about not wanting what he did to happen to himself, right?
Yeah, I did not include Dr. Woodcock.
or the statements that the defendant purportedly made to him, correct?
Yes.
Also, in your delineation of what took place in jail, you put down the things that we've heard about recently about the him jumping off the bed and running into the wall, those kinds of things. You agree you put those in there, right?
Yes.
But from the records, what you know is he did some other things too, like he tried to dismantle a handicap bar to make a club. Do you recall that?
Yes.
That isn't in your report, right?
It's not.
He tries to dismantle an electrical plate on a wall, correct?
Yes.
Not in your report.
Yes.
There's a video, and my guess is you didn't see it at this time, but there's a video that showed up later where he is trying to get out of his chains that keep him in a cell prior to court. Did you see that video?
I'm trying to remember. I saw the video where he's jumping at the wall and some of his bizarre behavior and trying to look through the door. And it might be, I don't remember.
Okay. And then you go through, when you finish going through that stuff, you then go to examinations. And that's something you have organized in your report as number 4, examinations. Do you see that?
Yes.
And one of the things that's important that you document in there before you get into the actual visits with him are that he is on a stable dose of risperidone, Lexapro, and Cogentin.
Yes.
Okay. And frankly, those are the meds he ends up being on pretty consistently from the first time you saw him till, as far as we know today, right?
Yes.
And certainly the same meds he was on then when he met with doctors Reed and Metzner, correct?
Yes.
All right, let's get to these visits, because in these visits, and there's 4 of them that you document here before you opine that he's insane, there are specific quotes that you attribute to the defendant, right?
Yes.
Now, there are things that you say that he says that aren't in quotes, and those we should treat differently, correct?
I'm not sure that should be treated. I put in quotes specific words.
Okay.
And it was a summary of the content of what he conveyed to me.
I want to make sure I know how important the quotes are. If you put quotes around it, we can take it to the bank that those are the words he said and the way that he said them, right?
Correct.
Now, in this first conversation you have with him on December 19th, 2012, you start to re-go through the background that you had indicated on an earlier page with him to get his input on it. Fair?
Yes.
And one of the things that you discuss is that when he gets to graduate school, he decides he wants to socialize more, correct?
That's what he said, yes.
And he attributes part of his not performing as well as he might have liked to the fact that he really wanted to socialize more, correct?
Correct.
And that helps explain his efforts at reaching out to Miss Dada to get her phone number, right?
Yes.
He ends up developing a core group of friends. Do you remember that?
Yes.
One of those is a guy named Ben Garcia. Fair?
Yes.
Did you reach out to Miss Dada or Mr. Garcia?
I don't believe they were available to me.
Okay. But you made efforts to get a hold of them?
Judge, same objection as before.
Sustained.
So to explain, I did not...
Hold on. Doctor, there's not a question.
Okay.
Go ahead, ask your next question, please.
You did talk about his girlfriend with him, correct?
Yes.
But really all you asked about was if he'd had a girlfriend and when they separated, correct?
That's what a brief outline in the report. I spoke to him more about it. I spoke to him about, did they have an intimate relationship? What did they do together? How did it go from his perspective? How did he think it went from her perspective?
Okay, and none of that's in your report. Fair?
In my report, it is not a transcript of every word over the hours that has taken place.
No, but it is a delineation of important facts to you in assessing the mental health of the defendant, correct?
Yes,
And one of the things that you do not put in your report is that more than just being his first girlfriend, that the defendant's first sexual experience in his life was with this woman, correct?
correct.
And that he was in love with her, correct?
He
Correct.
was.
And that she broke up with him.
Yes,
The other thing that you don't do with him or at all before you opine that he is insane or schizophrenic is go through with him the Gmail chats that he had with her over the course of their relationship.
I did go discuss with him the Gmail chats that he had with her, and it's briefly in my, I believe, May 2nd.
We'll get there. Now, there's another part where you start to talk to him about the thoughts that he has, and you indicate that he says he tried, and you put in quotes, blocking the thoughts of hurting himself. Do you see that?
I don't see it, but I know I did it.
Okay.
I wrote it down.
And when you put it in quotes, it means that he was blocking.
He was blocking, correct.
And he used that word blocking, correct?
Yes,
Now, you know from a review of all the other records and all the conversations that he's had with mental health professionals that were documented, his girlfriend, anyone that we have records of, he'd never used the word blocking before he talked with you on December the 19th, 2012, correct?
yes.
Mr. Brockler,
Yes, Judge.
one of the jurors needs a break.
Yes, sir.
So we're going to go ahead and take our morning break. All right, members of the jury, please make sure that you comply with all the admonishments I have been giving you throughout the trial. Let's take our morning break. I'll see you back here in about 20 minutes. Thank you. Please be seated, everyone. The record should reflect that we're outside the presence of the jury. Is there anything we need to talk about at this time?
No, Your Honor.
Okay, I'll see you after the break. Thank you. Please be seated. Back on the record, this is the people of the state of Colorado versus James Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. We are outside the presence of the jury. Let me follow up on an objection that I sustained shortly before the break. There was a question about whether Dr. Gurr had reached out to Gargi and to Ms. Data and Mr. Garcia. And if you want Dr. Gurr to step out, I can ask her to step out, either one of you. And I sustained the objection, and I think I assumed that this was the same issue that we talked about at the bench in terms of some kind of legal counsel or legal action pending, or legal counsel providing advice, and therefore making them unavailable. But I want to make sure that my assumption isn't wrong. Is that what was going on with them too? In other words, a situation similar to Drs. Fenton and Feinstein, or something else?
No, Your Honor, my understanding is that from Ms. Teach McGuire, and this was before actually I was on the case, as the court may know, was that neither of them had counsel at the time that this interview was conducted.
All right, Mr. King.
Judge, they were being represented by the university, and they did make themselves available to us very, very early on, but subsequently refused to talk to us.
But was it through the university's attorney?
Yes, that's what the communication came through.
Oh, okay.
They weren't being sued, as far as I know, as individuals.
Right.
Nor did they have private counsel, but they were being represented by the university counsel.
All right, and the university counsel then indicated to you that they would not be available to be interviewed?
They would no longer be willing to talk to us.
Okay, I wanted to make sure I hadn't assumed something that was wrong. Okay, let's bring the jury in, please. Please be seated. The record should reflect that the jury is back in the courtroom. Welcome back, folks. Dr. Gurr, I remind you that you're still under oath, and Mr. Brockler, you may proceed with your cross-examination.
Thank you, Your Honor. Dr. Gurr, there's a place in your report, a couple pages from where we were, where you asked the defendant about his thoughts during the shooting. Can you find that for me?
If you have it, can you tell me what page?
Again,
Maybe
the way I did this was to kind of cut and paste things into a thing. I don't have the
okay.
exact page.
Okay, it will take, I'm looking.
That's our second one.
May I ask you, is this on the first visit of December 19th we are on?
Well, I sure think it is, but give me a second here. I don't want to have screwed this up for you or for me. Hang on one sec.
Okay, I'm looking too.
Actually, you know what, that may be February or May, and I don't want to get out of order too much, even though I asked you to advance a couple pages over. Let's try to stick with January. Forgive me for that.
Okay.
You describe in the December meeting with him that he, after the breakup with his girlfriend, and it was really about 5 months that they were together, October through end of February, and then some sort of friend with benefits thing for about March. Is that fair?
After she broke up with him, they agreed to be together on friendly terms, and then he took the initiative of saying there's no point in this relationship.
So they were together about 5 months, from about October to the end of February, with some of that other stuff going on in March. Fair?
About, yeah.
Okay, and after that, he tells you, and this is in quotes, that he was incapacitated, lying in bed, unable to move. Do you see that?
I remember the words, but I'm not on the page.
It's a paragraph that begins, he was decompensating in graduate school.
Yes, I'm there, page 8.
Okay, thank you. And you see that part there where he was very isolated and incapacitated, lying in bed, unable to move. Do you see that?
Yes.
All right. Now, you've had a chance prior to this and certainly after this to look at everything that was going on, that was documented in the defendant's life at the time that his girlfriend broke up and even afterwards, correct?
Yes.
Can you tell me and point to what is the evidence, other than him saying it, that he was incapacitated, unable to move?
The section titled Examinations, Visit 1 through 4, specifically focus on the interview and the information that I obtained from Mr. Holmes. They do not include evidence from the outside on that. If you're asking me if I'm aware that during this time he was still going to school and it was being on email and was paying his bills and functioning and using his bike and going to the gym, I am aware. His report was that if we consider 24 hours a day, the number of hours that he was spending in bed, unable to function, preoccupied, incapacitated, his words, was higher relative to what it was before. And I was focusing on what Mr. Holmes was disclosing to me, the information that I obtained during the interview. So I'm not referring to anything else in these pages.
Is it fair to say then that before you opined that he was insane and schizophrenic in your June 2013 report, that you simply took the defendant at his word as to what was going on and what he did and did not check for corroboration with outside documentation?
Sorry.
That's okay, go ahead, ma'am.
No, I did have information. So this section of the report focuses on the details that I've obtained from him, only from him, during the interview. However, the final conclusion, and maybe you know when I was referring in the introductory section of everything else that I've reviewed and did not detail it, as you know, you've highlighted, is it relates to other activities that, you know, for example, to the chat with Gargi on May 2nd, which is on page 6 of my report. I discussed with him his shooting, everything that he was doing based on the outside. So it included, I knew what were activities in the outside. I know that he was going to school. I know, I've watched his presentation in the class, as part of the graduate school seminar, the required work. I've done all of this, but this is not what I focused on in trying to understand him, his state of mind during that period.
Doctor, what I'm looking for, I guess, is where, before you opine on his sanity and diagnosis, where do you push back and ask for more details from him, like, hey, give me an example of what you mean by incapacitated, especially in light of the fact that he's going to 24-hour fitness 5, 6, 7 times a month. He's going to King Super, shopping for the same foods in July that he was shopping for back in the previous August. Where's that sort of, hey, help me understand what you mean by these words before I rely upon them to say that you were insane on July 20th?
Objection, compound question.
Overruled.
Go ahead, doctor.
So incapacitated, as I said, referred to a general increased proportion of time that was difficult for him to mobilize himself to the same level that was required from him previously for schoolwork. So it's a proportion. It's not like that he was 24 hours a day lying in bed doing nothing. There was a greater time that he felt, reported feeling, that at this time he was incapacitated. His perception, his experiences were that he was incapacitated by the turmoil, his inner experiences.
Incapacitated and unable to move.
Yeah.
All right. But you'd agree with me that in reviewing the records that were available, even if you didn't include them in your report or you just considered them however, you'd agree with me, there simply isn't any documented evidence of the defendant's inability to move or incapacitation over any period of time before he walks into that theater on July 20th, 2012.
I believe that short of having a video camera in his own apartment and measuring the number of hours as he's in jail, measuring the number of hours that he's up and he's lying in bed, is moving or not moving at night and in the afternoon, it is his report that he was incapacitated. And I do take into account in the insanity, my conclusions regarding the insanity, that he has continued functioning and doing things that he was doing before, like shopping for food and doing other things that he was doing before. I do not believe that these preclude the status of insanity. At the time that he went, as you mentioned, that he went into the theater on July 20th, 2012.
Now, you'd agree with me that nowhere in this report of June of 2013 do you include any of the details of his activities in terms of working out on a regular basis, shopping for healthy food on a regular basis, continuing virtually uninterrupted in every other single activity that's documented in his life. You'd agree you don't put any
But
of that
I'd
in here.
object to the mischaracterization of continuing in every other area of his life.
Objection? The objection's overruled?
Go ahead, doctor. You don't put any of that in your report, correct?
It's not in my report, correct.
Okay. And so that we're clear, based on the description you've given us, when you use the phrase incapacitation or an inability to move, that does not impact his ability to do all the things that we just talked about that he was able to do that you didn't document, correct?
It is present to a degree as far as duration. It is present to a degree where he is able to continue his activities. There's a difference, I will say, between going to bed and sleeping, normally, and having a restful night, and getting up in the morning, and looking forward to the next classes and interactions, to lying in bed and pondering about and thinking about what am I going to do, my life is falling apart. I call it being somewhat incapacitated. And that's how he described it, and that's what I conveyed. This is not normal for a first-year graduate student.
Fair that you relied upon his description and characterization for that inclusion in your report, right?
Correct. All of the examination is totally based, the part of the report is totally based on his report, words, and my clinical observation. And I said that and I emphasize it. That's how I broke it down. Yes.
Without scrutiny to the other records that might suggest that what he's saying is untrue or an embellishment.
No, that's not the case. The purpose of this section of the report is to provide as a representative sample as possible of the information that I obtained during direct evaluation.
So that I'm clear, so that we're all clear. Your point wasn't to put in everything important in this report, but to just be a sample of the conversation you had with him? Is that what you just said?
No, I said that the section of this report of my evaluation of him, visit 1, visit 2, visit 3, is the information that I obtained from him during the evaluation.
Okay.
My conclusion at the end is based on all the information that was available to me at the time of writing this report.
Does your conclusion indicate in this report of June of 2013 that you found records that were inconsistent with his claims of inability to move and incapacitation?
It is not in my report.
Understood. Now, there's something else that you indicate right after that where you say, and you put this in quotes, that really the only thing that gets him going is he felt a call for action. Do you see that? And to develop a strategy in which shooting at others will be necessary. End quote. Do you see that?
Just 1 second.
It's right after the...
Yeah, I went back to the other pages, so I'll be...
Sorry. Take your time.
I'll be right with you. Yes.
Okay.
Correct.
Now, there's
I'm there.
couple things I want to ask you about his exact words to you there. He said that he felt he needed to develop a strategy in which shooting at others will be necessary, correct?
Yes.
Not a strategy where killing others will be necessary, right?
Shooting were the words.
But not shooting others, shooting at others. That's how you phrased it.
Correct.
And that's what he said, right?
Yes.
The other thing that's important here, it looks like from the quote, is that it was a call for action. Do you remember that?
Yes.
And because it's in quotes, you can take it to the bank. That's what he said.
Yes.
Right? That phrase shows up in this report opining on his schizophrenia and insanity no less than 6 times. Does that sound about right?
I didn't count, but I trust you counting.
Well, and you would remember that, man, he repeated this thing all the time. I put it in quotes many times, correct? Is that yes?
Yes.
The other thing that you notice then from the record is that after this report in June of 2013, 2 months later, a court-appointed forensic psychiatrist named Dr. Jeffrey Metzner begins his evaluation of the defendant, correct?
Yes.
And Dr. Metzner specifically asked him, within about 2 months of this report, did you ever use the phrase, a call for action? Do you remember reading that in his report?
Yes.
And the defendant says, I've never said that. Do you recall that?
Yes.
And in fact, Dr. Reed, who then does a forensic psychiatric evaluation of the defendant after Dr. Metzner, you saw the 23 hours of video, correct?
I did.
And the phrase, a call for action, shows up in there exactly 0 times. You'd agree with that?
Yes.
And yet, after that set of interviews, you then sit down with the defendant again in November of 2014, just 2 months before the trial starts, right?
Yes.
And he uses the phrase, a call for action with you again, doesn't he?
Yes.
That's interesting, right? You didn't find that interesting?
No.
Well, how about this? A call for action. He denies using it with Dr. Metzner. You read that part, right?
Yes.
Now, did you ever follow up with him in any of your subsequent meetings to the 2 court-appointed psychiatrists who found him sane and say, hey, why did you say you didn't say this to me? Did you ask him that question?
No.
You had an opportunity to review all of his writings that you've told us you had access to, his emails, his texts, his G-chats, his notebook, correct?
Yes.
And you would agree that nowhere in any of those does the phrase, a call for action, appear, right?
Right.
The only person who ever attributes that phrase to him is you, correct?
Yes.
Now, is it fair to go back and look at his past writings to see if that phrase has some particular importance to him? You'd agree with that? That's important, isn't it?
In reviewing his writing,
right, correct?
it can be.
So he denies saying it to you. You say he said it, correct?
Yes.
Maybe, I want to ask you, don't you think it's possible that this is a phrase that has some significance to you? And maybe it's from another case, maybe it's from some other thing that it has just found its way into this report. Isn't that possible? A call for action?
Unlikely.
But it could happen.
I mean, everything can happen, but I'm not surprised to your question, why did he say things to me that he did not say to other people?
No, that wasn't my question, Doctor.
No.
That wasn't my
I
question.
mean, that the call for action is something that he said to me and he denied to other professionals. It's possible that he will deny it. What was his state of mind when he was denying it? Did he want to appear good? He didn't want to appear sick. He did not. He was trying to do his best not to reveal the significant mental defect that he had. So I'm not surprised. And I think that I made him feel comfortable during the evaluation for him to reveal to me information. And that's not uncommon in people with schizophrenia, not whatsoever. Especially when I saw him, early in the course, and I spent significant amount of time and effort for him to establish some rapport with him so I can obtain information. And it's not that different from a call for action or from mission or from the floodgates. It's all very similar. It describes terms that are documented in his record and were obtained by the other psychiatrists that are very similar. I mean, we can go word by word. Was it action? Was it mission? Well, I think that it conveys exactly the same type of information.
Thank you. The quotes, though, were a call for action. You agree with that?
Yes.
And I just want to make sure that, and I appreciate that paragraph there, but I want to make sure that the question that I'm asking you is answered. And that is, you don't find in the record anywhere other than with you that this defendant has ever written, uttered, texted, chatted, or ever the phrase a call for action, correct?
Yes.
Question asked and answered.
Overruled.
Go ahead, doctor.
I said yes.
But that phrase, you agree, that phrase could have found its way into your report because it has special significance to you, correct?
I said unlikely. I don't think so.
Okay, Your Honor, may I approach the witness?
You may.
Doctor, you've written a book here. I want to show it to you. Called If Your Adolescent Has Schizophrenia. Is that it?
One we went over yesterday.
Is this your book?
It's my book.
There's a chapter 6. Can you read for us what chapter 6 is entitled?
Conclusion, a call for action.
Thank you.
That's a very different context.
Doctor,
Doctor,
wait for
thank
the
the
next
you.
question.
but-
Thank you.
Doctor, wait for
Thank
the
you.
next question. Go ahead, ask your question.
So that is a phrase that has had importance to you in another context, correct?
You want me to answer it and put it in context?
I want to ask you if it was important to you in another context, Doctor.
Totally different.
I understand. The phrase is a call for action. You'd agree, right?
I've used the summary of this book on a call for action in understanding mental illness in adolescent. It has nothing to do with the defendant, with Mr. Holmes. Nothing to do. I mean, look at when the
understand.
book was written. Totally out of context.
I understand, Doctor. Thank you for that explanation. There is a part in here where you talk about, as he saw it, life was meaningless, for him, was meaningless and not purposeful. Do you see that?
Yes.
And that turns out to be a repeated and significant issue for the defendant as he talks to you and other mental health professionals, that he feels like he's lost his purpose in life. You'd agree with that?
Yes.
And then you go on to describe this thing where he says that he tells you that he thought he would wound some, but didn't know he would kill. Correct?
Yes.
Now, I get that that's December 19th, 2012. That's your first time with him. But that must have struck you as completely inconsistent with every other document you'd received leading up to July 20th, 2012, correct?
Yes.
And you, before you issue this opinion saying that he is insane and schizophrenic, you do not confront him with those inconsistencies. Correct?
I did discuss with him, and you'll say it's not in my report, what does he mean that he was going to wound people and not to kill them?
You asked him that?
Yeah,
But we didn't even hear that on direct exam. Tell us. I mean, this will be the first time anyone's heard it, right?
that he did say wounded people. I mean, what if you read the entire sentence, is that he thought he would wound some, but didn't know or he'd kill.
Yeah.
And my conclusion from follow-up with him was that he found it difficult to tell me that he came into the theater to shoot and kill people. During the first evaluation, he tried to look good. So my conclusion was that he came prepared himself to kill people. And that saying, I came to wound people, was perhaps his effort to look good. He tried to look his best during the first evaluation.
So is it fair to say that despite the battery of tests and stuff that Dr. Hanlon gave him and Drs. Gray and Manguso and all that, the defendant, when he spoke with you and other mental health professionals, still retained the ability to manipulate the perception of what he had done and what he thought?
Objection, Judge.
Overruled.
Go ahead, doctor. He still retained the ability to do that, didn't he?
I don't see it as a manipulation you can call it manipulation. I don't see it as a manipulation. I see that, something that he mentioned about wounding people, later on killing people. It was just progression during obtaining information.
One of the things that's also absent from your report and your notes is any indication that you followed up with him after in this conversation where you said, "What are you talking about, man? You thought you would kill people. You intended to kill people." You don't ever write anything like that in here, correct?
I don't write it, but I discussed it with him.
You
of
did?
course I did, as part of the evaluation.
Part of the evaluation that up until this moment has been a secret you've kept?
Objection, Judge, to a secret that she's kept. This is in her report, it's in her notes, it's been testified to ad nauseum.
The speaking objection is overruled.
Doctor, you would agree with me that nowhere in your notes about December 19th, 2012, or your report do you indicate any follow-up with him about that statement, which you said at the time it was made you were skeptical of, right?
Yeah, it did not fit reality of what happened.
But you don't put anything in here about following up with him right there and saying, "What are you talking about? You went in there to kill people."
I did not put in my report question, answer, question, answer, question, answer. I was paying attention and conveyed the information accurately that he provided. He said exactly what I said. Was this real? No. We know what he did. We know, and I followed it up later on, and it's that he intended to kill people, as many as possible.
Yeah.
I'm not a fool.
Yeah. My question to you, though, was because of his ability to do that, you'd agree that even when speaking with you, a mental health professional, and presumably others, he retained the ability to manipulate the information that he provided to people to manage their perception of him. Would you agree with that?
Objection, Your Honor. It's commenting on credibility. That's
Overruled.
forbidden by the court.
Overruled.
Doctor?
I do not.
He did not have the ability to do that. Correct?
It did not. My conclusion, based on the interaction there, was that it was not, because it's something that was conveyed later on. It was not done in order to manipulate me to believe that he just came in to wound some people. No.
He said it to you to manipulate your perception of him. You've already told us that, right?
Objection, asked and answered.
Overruled.
Go ahead, doctor.
Objection, Judge, that was not what her testimony or her answer was. It's a mischaracterization of the witness's answer.
The speaking objection is overruled. Doctor, did you understand the question, or do you want him to ask it again?
Perhaps ask it again.
Ask the question again.
Thank you, Your Honor. He had the ability to try to manipulate your perception of him when you interviewed him on December 19th, 2012.
The reason it is hard for me to answer is that I don't see it, that he was sitting at that time in his chair and thinking, how am I going to answer a question so she likes me more or she thinks about me differently?
I understand.
You know?
There's also the phrase that you discussed with Mr. King yesterday, where you said that he picked the theater in response to a question you asked because he liked movies, correct?
This was his first answer
That's
to
right.
why did you pick the theater?
And-
Because I like movies.
And instantly you knew that's not the whole story, correct?
Correct.
And nowhere in your notes or your report does it show you pushing back on him or even confronting him with what he put in the notebook, which were months-long surveillance and casing of the Century 16 Theater, correct?
I did not put it at that sentence in the report, but I alluded to it later on.
Alluded
the
to it?
shooting.
Did you say
yeah,
alluded
it's
to it?
mentioned.
Okay.
I alluded maybe is not the right word,
We'll
but
get
it's mentioned.
Yes, ma'am. We'll get there. There was something else that you described with Mr. King where you recounted a part of a conversation where you said you asked him about school and walking down the halls and how, as he was describing the anxiety he felt walking down the halls at school, he became red-faced and emotional. Do you remember that?
Yes,
That's important enough to have put in your report, correct?
yes.
Can you find in your report where you reference that event? Him walking down the halls and then becoming emotional with you as he talked about it.
As I stated before, I did not include specifics in this report. I did not include what he told me for every component. The report is brief, but provides the information that I believed is important to convey and can be supplemented with me being here and being asked about it.
Good news, doctors. We actually have your notes that you took, as you described to us, immediately after that meeting where you wrote down, as you told us yesterday, all the important information that he gave you. Take a look at your notes, if you would, and find where you describe him getting emotional, talking to you about walking down the hallways at school.
It is not, I don't have to look, it is not in my notes on the high school, but that's what he told me. This was the context of the time that he got emotional, describing his anxiety walking down the hallways of high school. I did not, going out, as I said in the first report, I was concentrating on interacting with him, observing him, his demeanor, his facial expression, movements, and establishing rapport with him. I did not write at that time in his presence as soon as I left. Time was limited, and I did not write every event, but this is clear in my memory that this was the context of what was presented, talking about high school.
Is it fair then, in the absence of it being in your notes and your report, you are remembering it for us yesterday, July 7th, 2015, some 2 years and 8 months after he told it to you, correct?
No,
You're not remembering it from that?
I'm reporting it here a time after that, but I'm remembering it from the time that I've evaluated him and related it to the defense team.
So you told them about it?
Yeah, about the context of his emotions. Yes, it is not detailed in my reports. They did not correct or provided information for my reports. I did it, as I said yesterday, all by myself.
Now,
So-
that's helpful because you do document in your report his emotional responses to things that you talk to him about, correct?
Correct.
But not that one. Correct?
Yeah, I do not mention specifically high school.
In fact, the only time you attribute him becoming emotional, red-faced, grimacing like crying, lip shaking, hands tightening, he couldn't talk and was breathing deeply. That's from your report, right?
Yes,
And you said that that came up when he was describing his hopelessness, despair, pain. Do you remember that?
yes.
And the hurt he caused to the family members of those he killed, right?
Objection, Your Honor. May we approach?
Yes. The objection is overruled.
Forgive me, Doctor, I'm catching up. I think we had just talked about when you did document in your report that the defendant became emotional as you've previously described. You recall that?
Yes.
Okay. You go into, in another paragraph, you go into probing further about perceptions and experiences. Do you see that?
Yes.
And one of the things that he says is that he had heard noises but did not provide details, correct?
Yes.
You did not probe further about that, correct?
I did. It is not in my report how I probed and what question did I ask. What noises do you hear? When do you hear it? Can you imitate the noise if you have heard to me? He did not want to respond. He did not respond. I did not have information, but I probed. I did not take his word for it. In other words, and left the interview saying, oh, well, he heard some noises. I asked him. He did not provide an answer. He sat there.
To be clear, though, on that issue, you followed up with him and asked more probing questions, correct?
I followed up and asked probing questions on every issue. It is not documented, as you have pointed out.
Okay.
Question, answer, question, answer. But I did.
Okay, then the other thing, and it reads, he said he heard noises but did not provide details, end of sentence. You'd agree with that, right?
Yes.
You also write down, he also, quote, saw things moving in the room when no one else did, period, end quote. Correct?
Yes.
And then you write down, when I requested more details, he looked at the wall behind me and said, quote, right there. Do you remember that?
Yes.
And you actually demonstrated for us. He pointed at something and
Yes,
said
at
right
the
there.
wall behind, correct.
Now that is psychiatrically significant, isn't it?
Can be.
He's having a visual hallucination right in front of a
Yes.
psychiatrist. That's a big deal, right? Correct?
It can be. It's an important information to observe.
And document, right?
I documented.
Yeah, it shows up in the June 2013 report, right?
Yes.
I want you to go to your notes that you generated on December 19th in 2012 and find for us where you indicate that he says right there and points to the wall behind you. And I'll freely admit, Doctor, your handwriting is a challenge for me. That's not your fault, but if it's in there, didn't find it.
That he looked at the wall is not in the note that I took after the interview.
Nor is the part where you indicate he points to a visual hallucination he's having in front of you and announces right there, correct?
Judge, that's a mischaracterization of her direct testimony.
Overruled.
Go ahead, Doctor. Is that
So
in there?
what I said is that he looked at the wall when we were discussing. Let me read from my notes. May I?
Sure.
Okay. He also, quote, saw things moving in the room when no one else did, close quote. And at that time, he was looking, when we were discussing it, he was looking at the wall behind, and when I was probing, what do you see? He was pointing right there. When I left the room and I was sitting and summarizing quickly, I did not put it in my note. I recall it vividly. It was unusual, but it did not provide. I didn't say hallucination because there was nothing at the wall, and he did not say, what did he see? It might have been some light. So, it can be clinically significant, but it's not a detailed description here of an hallucination that is provided before. And I'm careful with, concluding from that. So say he saw things, and as I said in the next sentence, is that as it was toward the end of the evaluation, it was not the time to probe further. Probe further. I probed. I didn't get anywhere. So I did not call it an hallucination. I'm careful with the description of the information that I obtained.
Doctor, I just want to be clear then, based on this information you've just testified to, is that you asked him if he saw things no one else saw, and he agreed, right?
Yes.
And then he points during the interview to something behind you that you don't see, correct?
Turning at the wall, no. No, there was nothing at the wall.
But what did he point at?
At the wall behind.
Okay, he points at the wall.
Behind.
There's nothing there, right?
There's nothing there.
And he says, right there, in quotes, correct?
Yes.
That feels a lot like a visual hallucination. He is seeing things that aren't there, correct?
It might be. It doesn't detail it. My observation that I said I need to probe it further is that this is a behavior that can be consistent with a visual hallucination. It may be consistent. I do not draw a clinical conclusion when I probe and there's nothing that he can tell me and he sits quiet that I reported what I saw is exactly, he pointed at the wall. That's it.
Yeah, I understand. Doctor, you did not ask him any other questions that you documented afterwards, like, hey, what do you mean when you point to the wall at nothing and say right there? What are you seeing? That's not in your report.
It's not in my report. The sentence is, it was not the time to probe further because it did not provide further information and it was toward the end of the evaluation.
So you asked him, what do you mean by right there? Did you ask him?
I looked back. There was nothing there. What is there? There was no response.
Did you ask him, doctor, whether he saw something? Did you ask him, what do you mean by right there?
Yes, I did.
And what answer did he give?
He did not give an answer.
That is not documented in your notes or your report, correct? You don't say, I asked him and he did not provide an answer, or he refused to answer, or he just stared blankly at me. Nothing like that appears, right?
It does not appear. As I said, I did not record question and answer during that. What I said, it was not the time to probe further. I probed. I asked. I didn't get anywhere. The first report, the first encounter was very difficult. As I testified, it was like pulling teeth at the time.
I understand. Doctor, but the fact is this, when you sat down, as you described to us, immediately after this meeting, to write down all of the things that you believed were important, and I'm referring to your notes here, this is what you wrote down. He said he heard, quote, noises, but didn't provide details. He also, quote, saw things, unquote, moving in the room when no one else did. As it was toward the end of the evaluation, it was not the time to probe further. That's the extent of your notes, correct?
Correct.
And that means that 6 months, almost to the day, after you did not write this potential hallucination that occurred in front of you in your notes, you remembered it for the June 17th, 2013 report, where you opined that he was insane and schizophrenic. Is that true?
Yes.
Now, in this first meeting, there's only one reference to the notebook, and it's not even referred to as a notebook. You'd agree with that? Correct?
Can you tell me what you're referring to, please?
It's the very next sentence after he saw something right there and pointed to the wall, that part.
Okay.
It says, at that point, he mentioned that he wrote a journal
Yes,
He called it a journal. Is that right?
yes,
And it was to explain what he was going through, correct?
yes.
Now, you'd already seen the journal, correct?
I saw the journal. It's something that I told you I will check
Oh, yeah.
yesterday,
what'd you find
so
out?
I can report. I saw the journal on November 28th, 2012, for about an hour. I did not have a copy of the journal because of legal issues. I'm not familiar and did not inquire about the legal issues, but it was not left for me. The actual copy of the notebook or journal I received on February 13, 2013. So in the first meeting on December 19th, 2012, I did not have the journal with me. I had recollection and I did not write down notes when I saw the journal for about an hour, I did not write down notes based on that.
Why not?
Legally, the journal at that time was not made available to me. I looked at the journal in order to obtain preliminary information, and I follow the guidelines of the defense to maintain, the legal procedures. I'm not a lawyer, but the journal was not made available. But I wanted to take a look at the journal and went through it, I estimate about an hour, in order to consider, as I said, based on the information, including a review of the journal by myself, if it is consistent or suggests a psychotic process. And if you note, when I think it's on my note, at the end of the first interview, on that date, when you asked me to go yesterday over my handwriting, at the end of the page of my note, TTD, things to do, an abbreviation.
Doctor, forgive me. Do you feel like this is responsive to my question about whether you took notes about the notebook?
Yes, because I say, his notebook, things that I need to do is go over the notebook when you have it. I didn't have it
And we'll
to evaluate for psychosis.
Yep. We'll get into that in your May meeting, if we can get there, okay?
Okay.
Now, in this particular time, though, when he tells you, hey, I wrote this journal, these 28 pages that you spent an hour with, to explain what I was going through, you must have thought to yourself, wow, there's a good chunk of this that is actually just planning for this crime, right?
Yes.
You don't confront him with that at that time. Is that fair?
I had a different strategy.
Understood. But that strategy included not confronting him at that time about his description of the journal. Fair?
The journal, I was waiting to get the journal so I can go over it. Furthermore, I believe it was important to get information from him without the journal and any documents in front of him, to get his description, details in response to questions, and then coming back with the journal when I have it and review it with him, and I evaluated the consistency between what he told me without the journal and what he told me when he had the journal, and compared it also to the other professionals who have evaluated him with the journal. And I found it, many items, many descriptions were consistent. And this is not uncommon. It's not an uncommon approach. I think you get information provided without the journal that was not available to me.
Your Honor, I don't know the court's schedule. With the court's permission, could I go into one other quote before we take our break, or does the court want to take a break right now?
Well, you can do it if you can do it within the next few minutes, 5 minutes.
Okay, thank you, Your Honor. I want to refer you to another quote where you begin to talk with him about his thoughts during the shooting. Can you find that?
Yes.
And you put down as the words that he spoke to you, quote, getting killed was an option, comma, being captured was another, end quote. Do you see that?
Yes.
And that was said just like you put it there in quotes, fair?
Yes.
And all in one sentence fragment, correct?
Yes.
And it was in response to your question, what do you think's going to happen?
Yes. His thoughts during the shooting.
Yep, right,
Yeah.
right, exactly. That is, you would agree that that statement makes it seem like he didn't have an idea or a thought of what would happen when he engaged in the shooting, correct?
I'm not sure I understand your question.
Regarding being killed or captured, it sounds like because of that one very specific quote in response to your question, what do you think would happen, that he sort of looked at them as equivalents, like a 50-50. Is that how you took it?
I took it as an option. What can be the outcome? An outcome can be that I will get killed or I will be captured.
Now that's
I didn't ask him, is it 50-50?
I understand. That's different than, let's say, had you asked him, hey, couldn't you have been killed? And he said, oh, that's an option. And then you ask him, well, what do you think's going to happen? And he says, I think I'm going to be captured. That's different than what you just put in that quote right there, right? I mean, I'm trying to differentiate the two meanings that you would have attributed to those, correct?
I'm not sure what you're asking. I'm trying really to answer. I'm not sure what you asked me. I mean, I put down what he told me.
Okay. Well,
When I asked about the shooting and he said, getting killed was an option, being captured was another. That's it.
Just in one quote, that was how quick it came out.
Yes.
Okay, let's go to your notes.
Okay.
And if you find that session, I want to read that if I could, and you tell me if I'm misstating anything in there.
Okay.
Discussing the shooting. I asked if he thought he might get killed, comma. He said, quote, that was an option, end quote. He protected himself. I asked if he thought what will happen later. He said, quote, I will be captured. And I asked, and he said, I didn't think about it. Do you see that?
Yes.
That is actually the quote of what he said to you. Fair?
Yes.
That is not what you put in your report as the quote that he said to you, correct?
I don't see I don't see the difference. It's the same information.
You have taken answers to two different questions and combined them into a single quotation that you attribute to a complete.
Maybe I didn't put 3 little dots between the quote, the words that I put, but it conveys the information of what I've asked him, that he can be killed is one possibility. He might get killed or he might get captured. So are you referring that, in quoting it, because these are quotes in the note that I took, that I could be killed, ... or I could be captured.
Doctor, what I'm referring to is the fact that when you proposed to him, could he be killed, he responded, that was an option, but then told you he'd taken steps to protect himself. Then you followed up with, well, what do you think will happen? And he said, captured. That's not what you put in the quote. Is that fair?
Yeah, no, but there was much more. There was much more in the discussion of going back. I didn't spend, almost in that interview, almost, 3 hours of just, if you read this, you'll read it in 10 minutes. Even with a bad handwriting, I didn't spend that. I spent many, many efforts to go back and forth, and maybe I didn't put the 3 dots, but...
Doctor, it's fair to say you created that quote, yes?
Yes.
What other quotes did you create in your report finding him insane and schizophrenic?
I don't understand what you ask.
You created this quote. He did not say these words to you in the manner in which you put them in your report or you testified to him here today. That's clear. I'm asking you if you've done
Objection,
it
that
any other
misstates the witness's answer, Your Honor. It's a
Overruled.
mischaracterization.
Overruled, she's
Yeah,
free to
so
disagree. Hold
I-
on, hold on. Let me finish. My ruling is it's overruled. She's free to disagree if she wants to. Go ahead.
I disagree.
Doctor, you would agree now that the defendant never said to you, being killed was one option, comma, being captured was the other, as you have testified to and put in your report. He never said it like that, correct?
It is possibly a combined sentence, but the words are his words. And the only thing that I can say is that with all the information and repeated questions and doing it right after that, I did not put the 3 dots that might have been before. But to be killed, you know that this, and the option of being killed and being captured is the word that he used. Being killed or captured are the options that he used.
The other parts that are missing are the questions you asked to get there. Fair?
Yeah, and from your perspective, they're missing in everything else, and I said so, that the sentences reflect major points that I've brought up in its discussion, but it does not reflect question, answer, question, answer. It does not.
And it does not reflect accurate quotes, correct?
I believe that the quotes that you're saying is including words that he said, but maybe not in one sentence. There are 2 sentences, and combined, capture a couple of points, words that he used. But the major options that he considered at that time were that he will be killed or he will be captured.
Are there other places, before we break for lunch, are there other places in your report that you can think of where you took that kind of editorial liberty and combined answers into one quote to express what you thought was the gist of what he was saying?
Object to the form of the question as argumentative.
Overruled.
Doctor?
I can't recall things like that, and if you point them out to me, as you did now, I will do my best to answer your question. But I do not believe that what I've put there are words that he has not used.
Thank you. This is a good time now.
All right, thank you. All right, members of the jury, let's go ahead and take our lunch break. Please make sure that you abide by all the admonishments related to your conduct, okay? And I'll see you back here at about 1:35, all right? We'll take an hour and a half. Thank you. Okay, the record should reflect the jury has exited the courtroom. Let's go ahead and take our lunch break, and then let's have counsel back, maybe 1:20 or so, if it's okay, and then I can give you a ruling on Exhibit D-TR-97, or at least the reasons for the ruling, okay? So let's have you back at about 1:20. The court will be in recess. Seated. Good afternoon, everyone. This is the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The records reflect that Mr. Holmes is present with his attorneys and the prosecutors are present as well. And we're outside the presence of the jury. And Dr. Greer, you're welcome to sit there, but this is probably going to take a little bit. So you can step down if you like, whatever you wish, okay? All right. This is with respect to Defense Exhibit D-TR-97, which is a video recording taken by two defense investigators of the defendant while the defendant was in a hospital bed on Monday, November 19, 2012. And the video recording is about 25 minutes long, maybe a little bit shorter than that, but it is an interview of the defendant by mostly one of the investigators, although I think the other investigator may ask a question or two. It's hard to tell. They're asking the defendant how he's doing, how he's feeling, and then at some point, they asked the defendant about the night before and to talk about the night before. And the defendant talks about shadows, seeing shadows and hiding from shadows, hiding under the blankets from the shadows. And he talks about the shadows being present even under the blankets. I think he says that he's frightened of the shadows, that the shadows poke him and pick him up and do things to him. And then there's some detailed discussion of these shadows, and then from there, it's some more small talk about how he's doing. I think there's small talk about the Broncos and the Chargers, who played apparently the day before. Whether he needs anything. I think at one point they ask if he wants some water. They give him some water. And I think toward the end of the interview, they ask if they can. I think one of the investigators mentions that the defendant's lips seem dry, and so the defendant asks for, I think, some kind of lip balm, and the investigator indicates that he will talk to the nurse about that, as well as about getting eye drops, because the defendant indicates that his eyes feel sandpapery, and so they indicate to him that they will let the nurse know about that and see what they can do. In general, I would describe the defendant's demeanor as groggy, sleepy. He appears to barely be able to keep his eyes open. He is coherent in general, and he's able to carry on a conversation, and appears to understand the questions that are asked and appears to respond to the questions appropriately, but he seems to be, as I said, groggy, sleepy, perhaps under the influence of drugs. At least that's the appearance, and that's based on my observations. It appears that he may be under the influence of some drug or something, and he seems really almost, at least partially out of it, not quite alert, if you will. So the question is whether to allow the video recording under Rule 703. Rule 703 says that if of a type reasonably relied upon by experts in the particular field, informing opinions or inferences upon the subject, the facts or data need not be admissible in evidence in order for the opinion or inference to be admitted. Facts or data that are otherwise inadmissible shall not be disclosed to the jury by the proponent of the opinion or inference unless the court determines that their probative value in assisting the jury to evaluate the expert's opinion substantially outweighs their prejudicial effect. That's not the rule in its entirety, but that's the portion of the rule that's relevant to this particular issue. So Rule 703, for our purposes, provides that the facts or data on which an expert bases an opinion need not be admissible as evidence for the opinion to be admitted, so long as the facts or data are of a type reasonably relied upon by experts in the particular field. However, the rule states that if such facts or data are themselves inadmissible, then they cannot be disclosed to the jury by the proponent unless the court determines that their probative value in assisting the jury to evaluate the expert's opinion substantially outweighs their prejudicial effect. And I have watched Exhibit D-TR-97 twice now, and I have ruled that it is inadmissible. So I'm not going to repeat why I found it inadmissible, but I sustain the prosecution's objection to hearsay, and frankly, I don't know that it would pass muster under Rule 403. If I had to decide admissibility under Rule 403, I don't believe it would pass muster under that rule. But the question right now is whether it can be admitted under Rule 703. Rule 703, although it allows a party to disclose to the jury facts or data that are otherwise inadmissible in some circumstances, it cannot be used to undermine the other rules of evidence or to simply get around the other rules of evidence. And I think that's the argument that Mr. Brockler made at the bench yesterday, that the defense appears to be using Rule 703 to get in evidence that I have ruled is inadmissible. Now, I agree with Mr. Brockler, but I will say in all fairness that I said that I would entertain a request by the defense once Dr. Gurr testified for admission of this exhibit under Rule 703. And then I said we will see at that point whether the defense can establish the required foundation, and we'll go from there. And I'm finding now that the foundation cannot be established, and that furthermore, the exhibit is not admitted pursuant to the balancing test in the last sentence of the rule, or the balancing test that's mentioned in the last sentence of the rule. Rule 703 does not permit otherwise inadmissible facts or data merely because an expert relied on them. There's more to it than that. There's a foundational requirement, and then there's the requirement of the balancing test as well. And so let me address each of those two aspects. First, in terms of foundation, as far as I know, and this is based on my understanding of the comments that were made during the bench conference that we had yesterday in the afternoon between Mr. Brockler, Mr. King, and the court. If I'm wrong, I'm sure the parties will correct me, and I would appreciate being corrected. But as far as I know, no expert discussed the video recording specifically in his or her report. The video may have been listed as an item that was reviewed, but I don't believe that it's been discussed specifically in any report from any expert in this case. Certainly, neither court-appointed expert discussed it or its contents. I went back and looked at the report from Dr. Reed and the report from Dr. Metzner, and as far as I can tell, neither one of them discussed the video recording or the contents of the video recording. They listed it as something that was forwarded to them and something that they reviewed, but I didn't see any discussion at all of the video recording or any mention of it other than the fact that it was something forwarded to them and something that they reviewed. Additionally, and again, this is based on my recollection, and I'm far from infallible, so this is just the best of my recollection. Other than Dr. Gurr yesterday, no expert has testified that he or she relied on this specific video recording informing his or her opinions. Experts have talked about relying on everything that was in general they've reviewed, or all kinds of things that they've reviewed, but I don't recall anyone identifying this specific exhibit or singling out this specific exhibit as a basis for his or her opinion. Nor has any expert, again to the best of my recollection, other than Dr. Gurr, testified that the video recording is of a type that's reasonably relied on by experts in their field. And I note that the attorneys on both sides have had plenty of opportunity to ask each expert, other than Dr. Gurr, of course, each expert about the video recording, whether it's something they relied on informing their opinions, and whether it's something reasonably relied on by experts in their field. And none of the attorneys did so, at least based on my recollection. And neither party attempted to establish the foundation required under Rule 703 for this video recording with any expert other than Dr. Gurr. And when I said a moment ago that each attorney has had plenty, or the attorneys have had plenty of opportunity to ask each expert about this other than Dr. Gurr, I did not mean to imply that they haven't had that opportunity with respect to Dr. Gurr. The point is that Dr. Gurr is the only one that I believe has been asked about this, and that was yesterday by the defense. I understand and acknowledge that all the experts have received and reviewed the video recording. At least that's my belief. I don't know about Dr. Woodcock, but I know for sure Dr. Reed and Dr. Metzner received it, and I think they said that they reviewed it, although I'm not 100% sure if they reviewed it or not, but I know they received it. But that's not the same as relying on it for forming an opinion or to form an opinion. The experts in this case have reviewed tens of thousands of pages of materials and tons of CDs and DVDs. And the fact that they've reviewed these extensive, voluminous materials because counsel have forwarded them does not mean that their opinions are based on every single page or every single part of the materials. I note that yesterday Dr. Gurr only mentioned the video recording at the end of her testimony when asked by counsel on direct examination if she had relied on it informing her opinions in this case, and whether it is the type of material reasonably relied on by other experts in the field or by experts in her field. At least my recollection is that in rendering her actual opinions here in court yesterday, she did not discuss in any detail the time that the defendant spent at Denver Health Medical Center. In fact, I don't remember if she even mentioned that hospitalization in her direct examination testimony. If she did, then the record will reflect that, and I'm wrong. But I don't recall this being a big part of her direct examination or a big part of her opinions that were rendered here yesterday. Regardless, the rule implicitly requires that the information be viewed as reliable by some independent objective standard beyond the opinion of the individual witness. That's from TK-7 Corporation versus Estate of Barbouti, B-A-R-B-O-U-T-I, 993 Federal 2nd 722. That's a 10th Circuit Court of Appeals case from 1993, which relied on Weinstein's federal evidence in interpreting Federal Rule 703, which I believe is identical to CRE 703. That's the Colorado version of the rule. And that type of implicit requirement is missing here. All we have is Dr. Gurr saying that she thinks this is the type of material that is reliable for an expert in her field. So the first part is the foundation. It's not there. And so the foundation that's required has not been established in my view. Even taking Dr. Gurr's testimony at face value, that she reviewed this video recording, that she relied on it to form her opinions, and that at least she thinks that this is the type of thing that other experts in the field would rely on. I find that based on the record before me, that's not sufficient to establish the foundation that's required by Rule 703. And I might feel differently, and I might be more persuaded by Dr. Gurr's testimony if any other expert had agreed with her or had said something along the lines of, this is the type of thing that experts in that field, the field of psychiatry or the field of neurology or neuropsychiatry, any of those fields, reasonably relies on or is justified in relying on. But just her saying it is not persuasive to me and not sufficiently credible given the record before me. The second part is a balancing test, and that is I have to look at the probative value of the exhibit in assisting the jury to evaluate Dr. Gur's opinions and then compare that to the prejudicial effect. And the rule doesn't say prejudicial effect on what or on whom, it just says prejudicial effect. But in this case, I don't believe that the probative value in assisting the jury to evaluate Dr. Gur's opinions substantially outweighs the prejudicial effect. And I'll tell you how I interpret prejudicial effect here in a moment. But first, let me talk about the probative value. In terms of the probative value to assist the jury to assess Dr. Gur's opinions, certainly the jury does not need to watch the video recording to evaluate her opinions. As I mentioned, she did not refer to the interview, as far as I remember, or the contents of the interview during her direct examination yesterday until the end when she was asked about the recording and whether she relied on it. But I don't remember that being a big part of her testimony or her opinions. Further, I infer from the record that the attorneys in this case agreed that the video recording did not have probative value in assisting the jury to evaluate other experts' opinions. Otherwise, they presumably would have attempted to lay the necessary foundation under Rule 703 when each witness testified and would have asked me to admit the video recording so that the jury could properly assess their opinions. That did not happen with any expert who has already finished testifying. Again, that's based on my recollection, and if I'm incorrect, I'm sure the attorneys will correct me. The second aspect then is prejudicial effect. And the rule says that the probative value has to substantially outweigh the prejudicial effect. So it's not enough if it just outweighs it, like 51% versus 49%, for example. It has to substantially outweigh the prejudicial effect. And so I am mindful of that. This exhibit is essentially a testimonial interview of the defendant by his investigators. It's what it is. I have allowed experts to talk about their interviews of the defendant, including Dr. Reed's video recorded interview of the defendant, but those are different. Those are sanity examination interviews. This exhibit D-TR-97, is an interview by two investigators from the public defender's office. They're asking the defendant to describe for them what happened the night before or what he experienced the night before. It's a testimonial interview. And then the defendant goes into what happened the night before in terms of the shadows, in terms of hiding from the shadows. And then, as I said, there's some other small talk in there. And then there's some part of the interview that's related to how the defendant is doing and how the restraints are off of him now and how he likes that better, how he seems better, that kind of thing. This is different, in my view, than even the writings of the defendant at the jail. I admitted those, but I see this as very different. And it's possible that I may have felt differently about this video recording if it were simply a video recording documenting the defendant's hospitalization. So if there had been a camera, for example, in the hospital room recording everything, I might have felt differently. And my understanding is there is a surveillance video that's been admitted of the defendant while he was at the hospital. But if this was a camera that included sound and was simply recording at all times everything that was happening, perhaps I would feel differently. But this is a question-answer session conducted by two investigators who work for the defendant, who are working on the defendant's case. If I allow I may even have felt differently now that I think about it. It's possible that I may have felt differently about this video recording if it was one of the investigators simply video recording an interaction between doctors and the defendant, as doctors are asking him questions for medical purposes or tending to him. Even that possibly might have been different for me, but that, again, is not what this is. This is an interview of a testimonial nature by the investigators and the defense team of the defendant. If I allow the recording, the prosecution will not have the opportunity to cross-examine the defendant about it, unless the defendant chooses to take the witness stand, but then it will be up to the defendant. In fact, the prosecution would not only be deprived of the opportunity to cross-examine on this interview, this question-answer session by the investigators, but they weren't present during the interview. I'm not saying they had the right to be present, but the point is they weren't present during the interview. This was an interview that was conducted with, I think, on November 16, which is a Friday, actually on November 19, which is a Monday, excuse me, and the defense asked for permission from the court to bring a camera to the hospital. That was through motion D-22, an ex parte motion that was signed by a judge other than Judge Sylvester, because Judge Sylvester was on vacation, I believe, and the order says that the defense has or is permitted to videotape the defendant 1 hour per day. So I have no way of knowing if there was any other recording performed, and this exhibit is a selection among the recordings. And of course, it would be improper for me to ask defense counsel about that because that's attorney work product. In the video recording, as I said, the defendant appears groggy and under the influence. He's generally coherent, but he's clearly groggy and sleepy. I don't know what, if anything, was said to the defendant before the interview in terms of an explanation for the video recording. And I don't know whether anything was said at all or an explanation was given. I know from the video recording that there's no discussion with the defendant as to why he's being video recorded or why the investigators are recording this. And the defendant doesn't ask, hey, why did you bring the camera in here? Or why do you guys have a camera? Or why are you recording me? So I don't know if anything was said beforehand, and if so, what was said beforehand. The defendant is coherent enough to be aware of the pending court proceedings because he specifically asks the investigators about that. And there's very small talk about that. There has been a lot of testimony from Denver Health Medical Center medical staff in this trial. And I have admitted medical records from at least 2 doctors at DHMC related to the psychiatric treatment provided to the defendant at the hospital in November of 2012. Some of those records, I believe, mentioned that the defendant said that he was hiding under the covers because of the shadows that he was seeing. To the extent that the video recording mentions that as well, it is cumulative. To the extent that the defendant is asked by his investigators to elaborate on that and to provide more details, or to the extent that the defendant provides more details, then I'm not aware that any of those details are contained in the medical records from DHMC. And again, if I'm wrong, counsel, please correct me at the end of this. I don't recall that in any of the medical records. I know that Dr. Metzner specifically mentions in his report the statement the defendant made, I think it was to Dr. Weintraub, about hiding under the covers because of the shadows. But I don't believe that the medical records from either Dr. Weintraub or anyone else go beyond that and talk about some of the other details that the defendant provides in this particular interview. If I'm right about that, and by the way, I don't remember any other part of the record containing those details. Again, if I'm wrong, then please correct me, but I believe this is the only place where there is this discussion. If I'm right about that, then these more detailed statements about the shadows poking him and picking him up and doing things would be at least arguably inconsistent with the medical records at the HMC and perhaps the trial record. I know that I checked Dr. Reed's report. Actually, it was Dr. Reed's transcript. And there's conversation in that interview that Dr. Reed did of the defendant about shadows. And he doesn't mention those specific or more detailed statements. And in fact, he says that he's not, I think, to paraphrase, the way I understood that interview is that he was not scared of them and that he could summon them when he wanted to. That's different than what this video recording contains. So that's something that I take into account as well. And those are the defendant's own statements to Dr. Reed about shadows. The reliability of the statements given, especially given the condition of the defendant, especially given that this is an interview conducted or an examination conducted by just the investigators for the defense without an opportunity for cross-examination, is of concern to me. The fact that the medical records at DHMC are inconsistent with the more detailed statements in the video recording is of concern to me because the defendant is at DHMC to get treatment, and he's being treated by the psychiatric unit of the hospital, and there are multiple people tending to him. We've heard from several people who have come in here and have talked about how they were monitoring him closely. They were asking him questions about what he was experiencing. They were making observations in the medical records about what he was saying, what he was doing, his demeanor, his behavior, all those things. And here we have an interview during the very same time frame at Denver Health Medical Center by the defense team, without any medical personnel present, without anyone else present, that appears to have different information than the medical records which were generated at the same time. I mean, just during the same time frame, during the same hospitalization. So that too is a concern for me. And finally, a concern I have is that this video recording contains not only the statements of the defendant, but it contains statements by the investigators. And there are some observations that the investigators are making as they're questioning the defendant. Some of those observations are just in the way of observations, and some of them are included within the questions that they are directing at the defendant. That too is a concern for me in terms of this video recording being admitted under Rule 703. So for all those reasons, I find that the probative value of the video recording in assisting the jury assess or evaluate Dr. Gur's opinions does not substantially outweigh the prejudicial effect. And I also find that this is problematic, as I said, under Rule 403. This exhibit is problematic under Rule 403. All right, anything with respect to that? I'll have the people go first since it was your objection, Mr. Brockler. Anything on behalf of the people?
No, sir, thank you.
All right, the defense, Mr. King. Anything on behalf of the defense?
1 minute, Your Honor, please.
All right, take your time.
Your Honor, that was a lot to take in. Would you mind if we, giving us an opportunity to respond at the end of the day or early tomorrow morning?
That's fine. Yeah, I don't have a problem with that. And like I said, I'm doing my best based on my recollection. And, you know, if I'm wrong, then, you know, please correct me. But that's the best of my recollection. So, all right, let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury is back in the courtroom now. Welcome back, folks. I hope you had a good lunch. Great. All right. Dr. Gurr, you're still under oath. And Mr. Brockler, you may proceed with the rest of your cross-examination.
Thank you, Your Honor. Doctor, we had finished by talking about one of the quotes that you had attributed to the defendant in your report. Do you recall that?
Yes.
I want to move on to another one.
Okay.
Also from that December 19th, 2012 time period, there is a sentence that follows the one that you quoted about death was one option, getting captured was the other. Do you remember that? That next sentence says, he stated that he had a mission, comma, quote, an awakening, comma, I had to do it, comma, I must do it now, end quote. Do you see that?
I don't see it, but I recall it. Let me.
Okay. Should be right after that part we just talked about in your report. But, ma'am, doctor, bottom of page 8 of your report, and I mean very bottom of page 8.
Yes, thank you.
Found it.
Thank you.
Okay, good. So the question was, you recall writing in there, he stated that he had a mission, comma, quote, an awakening, comma, I had to do it, comma, I must do it now, end quote. You remember that?
Yes.
And the parts that are in quotes are what he said and how he said it. Is that fair?
Yes.
What is not in quotes is the word a mission. He had a mission. Do you see that? It's right before the quoted part, an awakening.
Yes.
Now, that's not in quotes because that's not the word that he chose, right?
He used the word mission frequently, and it might be that I omitted putting it in quote then, or I added the word mission because it's a word that he used before.
One of the things that you'd agree with is in reviewing all of the writings of the defendant, including the notebook and the jail writings after his arrest, the G-chats, the texts, the emails, everything, that prior to this exchange, the defendant never uses the word mission. You'd agree with that?
Yes.
Now, in this particular case, looking at your notes, not the report, it appears from your notes that you are the first person to inject the word mission into the conversation through a question. Do you see that?
Judge, I'm going to object to the question, the phrasing of the question.
Sustained. Rephrase your question.
Thank you. Do you take a look at your notes? It looks like you are the first person to use the word mission in this conversation with the defendant in December of 2012. And I'm going to refer you to what I think is the first use of it, and you tell me if you see that. It says, I asked if his mission was accomplished. He said no. And no is in quotes. You see that?
Yes, but I believe that I was repeating the word that he said and that I was not creating the word. He was talking about a mission, something that he had to accomplish.
Okay, a couple of things. You'd agree that you didn't write that in your notes as he said it, nor did you attribute any quotations around it. You'd agree with that?
Yes.
Okay. Let's move on to the next part of that phrase, which is an awakening. I had to do it. I must do it now. Do you see that?
Yes.
An awakening sounds pretty unique, doesn't it?
Yes.
And did he tell you what he meant by an awakening? Because it's not in there.
A call for action, something that needs to be done.
But an awakening from what?
from his state of despair, believe that the world is coming to an end, there's nothing to be done, I will never be a neuroscientist, a movement, something that will move him forward.
And this is something that you wrote down in your June 2013 report, correct?
June,
May we have a page number, Your Honor?
June.
Still the bottom of page
You meaning
8.
June?
This is your
I
June.
don't.
This is your
You
June.
mean in my notes, not in my June?
Ma'am, yes. The report that we're referring to where you put down this quote, an awakening and the rest of it, that report was generated in June 2013.
The first report, yes.
Thank you. Now, I want you to go back to the notes that you generated in December of 2012, some 6 months before this. Do you have those in front of you?
Yes.
Again, it may be in there. I don't read your handwriting well, but can you please find us where you write down that quote, an awakening?
I do not have the quote in my notes.
And you didn't write it down at the time, correct?
Correct.
So 6 months after the interview and several interviews afterwards, as you sat down to write this, you recalled this exchange.
Yes, several of the words that he has been using were quite unique, such as awakening, master power, call for action, and I remembered them.
Not unique enough to write down at the time. Fair?
Didn't consider writing it down within the limitation of the time available.
Limitation of time? Who put a limitation of time on you?
You know, the travel, how many hours do I have after that to summarize it and get back? So
it was just sort of a self-imposed travel limitation?
part of it, yes.
Okay. Now, you certainly had the opportunity to review these notes before you wrote the report in June, correct?
Correct.
Okay. Now, when he says to you, I had to do it, I must do it now, does he clarify for you what now meant? I mean, did he mean March, April, May, June, July? What was now?
Now means more getting ready. There was no specific date provided, but it's something that need to be acted upon in the upcoming future. There was no date.
Well, later on, I think the next page, he then tells you that when he reached the conclusion that he must follow the call for action, he began to order the weapons. Do you see that?
On page 10,
I hope it's 9, but it could be 10.
page 9,
Yeah, let me take a look. Ma'am, the section ends with only way to get out of being immobilized. It was a call for action. When he reached the conclusion that he must follow the call for action, and I'm sorry, I cut and pasted it into my notes, so I don't have these.
I'm looking for it,
Yes, ma'am.
please. Mhm. Yes, I'm there. It's the last line before visit 2, February 9th morning, 2013.
Great. Thank you for finding that. So it's just at the top of the next page. Is that right?
Correct.
Now, that indicates that when he began to order the weapons was about the time he felt the call for action. Do you agree with that?
The call for action came a little bit before. It was not like it didn't occur at one day. He was struggling. But when he realized that this is a mission that has to be pursued, he began to purchase the weapon. So this is later on in, it's not day, it's not like a specific day to day. It's more like toward later on in the spring.
So if we were to know when he started ordering the weapons, we could determine that it was prior to that he felt this compulsion?
Correct.
Do you remember when he attempted to make the first weapon purchase?
I believe that the first weapon was not successful, and he purchased the Glocker in May of 2012.
What about the cell phone stun gun and the folding knife that he was going to use for serial killing?
I believe that he had it before of that.
Do you remember when he purchased that?
I don't remember the date.
Based on your understanding of what you've written in your report, would that, quote, call for action have occurred prior to the cell phone stun gun and the folding knife?
It was a repeated call. It wasn't something that occurred just one time, but it's something that was happening continuously, getting mobilized to do something. So I cannot tell you if there was a specific day or time before they did the call and then he got it. It was over a period of several weeks that this was evolving.
I understand, but I just want to be clear. That call for action, whenever it started, it would have been prior to the cell phone stun gun and the folding knife. Is that your recollection?
Part of it, yes.
Okay. Let's go to your February 9th morning meeting with him.
Yes.
Now, you indicate in there that he felt that shooting others, quote, can rid them of their problems and put them out of their misery, period, end quote. You see that?
Yes.
Now, one of the things that's important about that is it looks like he thinks he's doing a favor to the people that he's shooting. Is that fair?
He didn't put it as a favor, but as more of as an explanation of a part of life is not worthwhile for me. It has no value. Death equals life, and didn't think that it has value for other people as well, and that there will not be. All people do not feel. All people suffer. Life is meaningless for other people as well. So taking lives of other people will put them of the misery.
And you'd agree with me, putting someone out of their misery is doing them a favor?
It can be interpreted this way, yes.
Can you find an interpretation of it that's not a favor?
No, I agree that it will go more as something, that doing something.
Now,
But-
you go ahead. I'm sorry, doctor.
No,
finish.
go ahead.
So I was going to ask you, though, that you put that in quotes because those are the exact words that he used, correct?
Yes.
Now, I want you to go to your notes from that February the 9th, 2013, and you use slightly different language for what he told you. Do you agree?
Since he can't do that, shooting others can put them out of the problems too.
So, to be fair, you changed the words problems to misery from February to your report in June. Is that fair?
I believe that on further probing on that, he used the word misery as well.
And again, of course, clearly not documented in your notes.
As other points that are not documented in my notes, there was no writing of line by line, but problem and misery are similar.
Similar enough to not document that he added that change later after you probed him further on that. Fair?
Correct, I did not document all the probing.
Now, there is a next section here where you say, when he began to get the weapons, he thought he was acting in self-defense and got protective clothing. Do you see that?
Yes.
Now, describe that to me. What did he mean there? I presume you did some
That
further undocumented
when
stuff.
when I asked him about the first weapon that he obtained, he said that he got the gun for self-protection
From what?
from potential intruders. That was the explanation that he gave me, that Hillary had her screen cut and that it needs to be protected.
So just to be accurate, first off, none of that appears in your notes or your report. You'd agree with that?
Correct.
But your recollection is, these many months later, is that the defendant told you that he bought the gun because Hillary's screen had been cut at her apartment. Is that right?
In response to my questions, when he said, I bought the gun, and he showed it to a friend, he showed the gun to a friend, why did you get this gun? For self-protection. And I asked, was there any crime in the environment? Do you live in an area where there's a lot of crime that requires protection? And he said that Hillary's screen, this was his explanation to that.
And you remember that independent of any notes or report from a couple years ago?
There is also, I believe, a note on the discussion from Hillary in email about her screen being cut.
Your recollection is she puts in that text message and that people...
There is in some of the correspondence between them is that there is something that relates to her screen, to the best of my recollection, that this is something that she went through. Was this a motivation for him to get the gun? I doubt it, but that's what he said, and I report what he's saying.
I want to read to you the phrase, okay?
Yes.
Because the Hillary part isn't in there. He thought he was acting in self-defense and got protective clothing. That's all one phrase. Agreed?
Correct.
Did he get the protective clothing also for the screen being cut?
No. So it might be that the sentence is too condensed, and I'm sorry, or that my style of writing might not be up to par, but he got the first gun for self-defense, with Hillary mentioned, with me probing Hillary experience, from what I recall, mentioned at that time. I then proceeded to ask him about other things that he has purchased, and for example, the self-protecting clothes, and this was for protecting himself, from protecting himself down the road as he was to accomplish his mission.
And again, none of that appears in your report or your notes, correct?
That's what my report meant. He did not get the protective clothes to protect himself from potential intruders, but to protect himself during the time of the shooting.
Well, and the way you've written it here doesn't have anything to do with intruders. It's just he thought he was acting in self-defense and got protective clothing. Fair?
So what I'm providing, as I've done before,
Yes.
is more detail that will put the sentence into context. His gear was not for intruders. The gear, as I don't believe that the first gun was for intruders. I don't take his word for it. We can examine it further. It was part of the process of obtaining weapons. The gear was part of the process that he was going through to accomplish the mission.
Well, while we're there, in February of 2013, did you have an exchange with him about why he thought he needed body armor head to toe for the favor he was going to do for those in misery?
To protect himself.
From who?
Not from the people that he shot, but from potential from police.
Is that what he told you? That he bought the body armor to protect himself from police?
For his own protection, yes.
Did he tell you from police?
I don't remember if he said the word police or law enforcement, but yes, to protect himself.
And why would he think the police would want to shoot him for doing these people a favor?
Objection calls for speculation.
Doctor, you can't speculate, but this question, I believe, is going at what he said to you. Is that right?
Yes, sir, thanks.
All right.
And I can rephrase that.
Please.
What did he tell you was the reason he thought the police would want to shoot him?
I mean, he was going, as part of his mission, to shoot people. And there were two possibilities. The possibility that he will get killed, that he will be shot at during that time, or he will be captured. So the self-protection, the gear was to protect himself in case he shot.
My question, I suppose, and I don't mean it to be difficult, it feels obvious, is did you ask him why he thought he would either be shot and killed or captured for doing this favor for the people in the theater?
It was not, I mean, you put it in as a rational thought. I'm doing people a favor, as if it's a rational act to kill people for a favor. This is part of his delusions. He did not think that he will stand, I mean, I don't think, that he will stand with the police and negotiate and say, don't shoot me, I just, these people are, I'm doing them a favor. It didn't work like that in his delusional system.
So it sounds like he doesn't tell you why he bought armor anticipating that he would be shot or captured by members of society called police officers, right?
No, he did. I mean, I did say that I'm not sure if he said the word security forces or if he said police, but he was aware and prepared himself to be killed.
And let's just take that one step further. Based on your conversations with him, even back in February of 2013, he knew that those people would perceive his actions as wrong and worthy of killing him or stopping him, right?
Objection calls for speculation.
Overruled. He said based on your...
That these people...
Hold on. The question was based on your conversations with him. So it's calling for what he said, so the objection is overruled.
Go ahead, doctor.
That he knew that what he was doing was illegal, but he did not, in his state of mind, he did not have the capacity to distinguish between right and wrong and appreciate that with society morals, the act that he is doing is perceived as wrong. He did not go through this thought process that determines that. He did not have the capacity to do that.
You'd agree that he knew, really without a doubt, that certainly police officers would think what he was doing was wrong and worthy of shooting him for doing it.
Was illegal.
But do you understand my question? Did you understand my question?
No.
That he believed that police officers would view what he was doing as wrong and try to shoot him or capture him to keep him from doing it. You agree with that?
Objection calls for speculation.
Overruled.
Go ahead, doctor.
He knew it was illegal and that police officers will shoot him for committing this act. But I do not infer from that he was at that time at a state of mind distinguishing right from wrong.
Doctor, and I didn't ask you those questions. You understand my question was about what he conveyed to you about believing police officers would try to shoot him or stop him for what he was about to do, right?
Yes, the police officers, yes.
You'd agree with me that speeding down the road is also illegal, correct?
Yes.
And nobody would expect that the police would try to shoot them for speeding down the road, correct?
Objection calls for speculation.
Sustained. Rephrase your question.
Doctor, do you think that people would conclude that any police contact where they're breaking the law would result in their potentially being shot?
Objection calls for speculation.
Rephrase in terms of people.
How about this? And I'll shift gears. Thank you, Your Honor. Doctor, it's not like he said, I needed this body armor to protect me from the crowd of people in the theater I was going to shoot. It's not like that, right?
Correct.
He only needed it for the police, correct? Is that right?
Yes.
He didn't need it to look ominous or imposing so 400 people didn't rush him and try to stop him from murdering them, right?
Objection calls for speculation.
Once again, Doctor, you should answer the question only based on what he said to you. The defendant said to you, not based on speculation.
He did not say that he obtained the protective gear in order for people not to jump him. He did not say jump on him. He did not say that.
Or to rush him. He
He
didn't
did not say that.
All right, now let's go to this. There's another part of your report here from that day where you said, when looking in the mirror, he saw another guy. Do you see that?
Yes.
The rest of that reads, and had a sense that something, comma, quote, a master power, end quote, had taken over, period. Do you see that?
Yes.
A master power is a phrase, I think you may have already indicated this, appears nowhere else in your notes from any period of time, right?
Yes.
And when he's referring to a master power, based on the way you've written this, he is talking about the person he sees in the mirror, correct? Do you read that? When looking in the mirror?
I read it, but I don't. This is not what I intended to convey. It was in the context that I asked him about why did he dye his hair red, and he wasn't. He said he doesn't know why he dyed his hair. But when I asked him, what is it? What caused you to dye your hair? I mean, you changed your appearance. He said, maybe to distance myself from him, from that person that he could see in the mirror. He is not me. So the person that he looked at the mirror with the red hair was not James Holmes. Some separation, distancing himself from that person. It was like another guy. And he had the sense at that time, it's not quite just looking at the mirror, but at that time, he had the sense that the word master power, when following up with him, was not a power that was, a omnipotent power that was pushing him, but a strong power, a strong push, similar to the call for action, mobilize, that has taken over, that is propelling him to move according to the mission, to his actions.
You'd agree that the phrase a master power is one that he came up with, not you, right?
Correct.
And you'd also agree that that phrase not only doesn't exist anywhere else in your notes or any other conversation you've had with him, but you don't see it anywhere in the record of these 100,000 pages, right?
Correct.
So it only appears in your June 2013 report where you find him schizophrenic and sane. Is that fair?
Objection asked and answered.
Overruled?
Go ahead.
Can you repeat the question, please?
Yeah, that phrase, a master power, exists nowhere in this case other than in your June 2013 report where you find him to be insane and schizophrenic. Fair?
Correct.
Now, you also know that Dr. Woodcock talked to him about such things and asked him about whether or not he had thoughts of control. And his answer was no. Do you recall that?
Yes.
And that was a statement he made 4 days after he walked into the theater to kill all those people, right?
Yes.
Now, you get into part 2 of your February 9th meeting with the defendant.
Yes.
And one of the things you begin to flesh out here with him is that he is now telling you that the universe has no future and there is no reason for it to continue, correct?
Yes.
Now, you'd agree that that statement itself doesn't suggest the universe is coming to an end. He just doesn't think it should keep going. Fair?
It's a consistent statement.
Yeah.
The universe should not continue going. It's coming to an end.
Well, no,
When
and
something doesn't continue, it's at the end.
well, and forgive me. The quote though here is, "There is no reason for it to continue." Correct?
Yes.
Then later, he says to you a quote that you attribute to him anyway, that says, quote, "No future for me means no future for the world, means death is better for all." Do you see that?
Yes.
First off, you'd agree that this entire exchange about the world coming to an end and death is better for all, that appears nowhere else in any of the mental health experts' reports or any of the other discovery in this case. You'd agree with that?
Objection, misstatement of the evidence.
Overruled.
Can you repeat the question?
Yeah, the quote, did you find it? "No future for me means no future for the world, means death is better for all." Do you see
Yes.
that? Yeah. That quote doesn't appear anywhere else in discovery, right?
Not that quote, but similar words that there is no future and that the death is upon us.
Now your quote,
Appear.
yeah, I'm sorry, your quote, and that's in quotes. In your notes, the quote was written one way, and then it looks like you went back and changed it. Can you find it in your notes?
The notes of when?
Of that second meeting that you had with him in February, where you came up with the words "no future for me means no future for the world, means death is better for all." Do you see that?
I'm looking for it. Just a minute, please. The universe has no future and there is no reason to continue. He believed that other people feel the way he did and that death is the rational step. No life for me equals no life for others. He was not angry. That's what you mean?
No, ma'am. The quote that you wrote, which was in your notes, "No future for me," equal sign, "no future for the world," equal, "all want death." And then you scratched out "all want" and wrote "is better for all after death." Do you see that?
In my notes,
Yes, ma'am.
I don't see anything scratched out. I don't see.
May I approach the witness, Your Honor?
You may.
That's the copy. I don't know. I don't know the page, but may I show you what it looks
Yeah,
like in my notes?
sure.
Judge, I would like a page reference if I could.
Well, he said he doesn't have the page, right? Do you have the page number, Mr. Brockler?
I don't, Judge. I could go back through
Wait.
my notes. I kind of cut and pasted it without that, and I apologize. It's the very last thing you
the last
wrote on there. Do you
sentence.
see that?
Okay, I see it.
Can you tell Mr. King what page that is on your notes?
On my notes, it's the last page of visit 2 of February 9, 13, in the afternoon. The last sentence, the last.
You see it, right?
Yeah,
And the phrase "all want death," you have scratched out "all want" and have added "is better off for all" at the end of it. Do you see that?
yes.
Okay. Now, there's another portion in your notes where you talk about him in the laboratory experienced seeing a shadow that when he
So-
turned around was not there.
Back to my report.
Yes, ma'am.
sir?
Sorry. I'm
Okay.
sorry. Yep.
Just 1 second, please.
Yes, ma'am.
We're still on February 9th in the afternoon, right?
I think so, ma'am.
Yes, I'm there. Page 11 on the top.
Yes, ma'am, thank you. And you see that in there, correct?
Yes,
Now, there's no amount of probing that resulted in him telling you that those shadows at the time were dancing, right?
not at that time, no.
Or that they had shadow swords or guns, correct?
Correct,
Nor that they were juggling shadow heads.
correct.
In fact, towards the next part of that section, his other reference to shadows is that he saw them in his cell, and he told you that he jumped off the bed expecting the shadow to catch him. Do you see that?
Yes,
Okay. Now let's go to May 2nd, 2013. This will be your last meeting with him before you write your report, correct?
yes,
And it's also the meeting at which you have full access to the notebook based on what you told us previously, correct?
correct.
Because you'd gotten it, about 3 months earlier, almost, February 13th. Do you remember that?
Yes,
Okay. Now, there's a paragraph that begins by the second term of high school freshman year. Do you see that?
yes,
Now, you indicate here another quote, I suffer, other people suffer, all will be better off if everybody on earth dies, correct?
yes,
Later on, you talk about him, hang on here, the shooting was impersonal. Can you find that sentence?
I'm turning the page. Yes, I found it. The last paragraph paragraph before the last on page 12.
And it says right after that, he says that he dressed differently for it being the shooting. Do you see that?
Yes,
And the dressing differently that you're referring to there is he wore body armor, right?
yes,
That's how he dressed differently, correct?
and he had the face,
The gas
covered.
mask.
Gas mask, yes,
And we'll talk about that in a minute. But it's not like he put on different clothes than he normally wore. He was wearing the body armor to protect himself from the police, you thought.
yes,
Okay. You then go on after that to talk about he believed that his low self-value arise by incorporating the, quote, value of accomplishments and future potential of the people he will kill. Do you see that?
yes,
First off, to be clear, when you talk to him about it, he never tells you anything like, I get 1 point per life, did he?
At that time, I believe, let me see, as you stated, I did have is we are on May. We are on the May
Yes, ma'am.
2nd
Yes, Doc.
interview, correct?
Yep,
So I began to go over the report with him on the May 2nd interview, going through it first time, more quickly, making sure that I understand the symbols, and then in the following interview, going over it again, putting some notes that I provided to you. So there was already in the notes, in his notebook, the symbols and the values of people.
And were those values just ones? Each person was worth one?
Yes,
Okay. Your quote in here in May is that the value of accomplishments and future potential of the people he will kill will come to him, correct?
Correct.
He does not tell you it is a 1 point per life sort of proposition, correct?
Objection, misstatement of the evidence.
Overruled?
Correct?
Yeah, can you ask again, please?
Yes. He didn't tell you in that quote that he gets 1 point per life, correct?
Going over it for the first time, at that time, quickly, throughout date, I do not recall that he said it's 1 for 1, but it's the value of people.
Right, and the value is dependent upon things like children are worth more because they have more future potential. You'd agree with that?
Yes,
Now, that's not in the notebook, right?
it's not, it's my questioning.
Right, and that doesn't actually appear in your report either, does it?
It's on the note that I took.
I'm sorry?
It's on the note that I provided you with.
The note?
Yeah, from my notes on the
Oh,
notebook.
I know what you're talking about. You're talking about the notes that were provided to us Sunday night of this past week. Is that what you're talking about?
Yes,
And we'll get to more of the notebook here in a moment. But in your report and in your notes on that report, you never once talk about the fact that he thinks it's a 1 point per life proposition, correct?
Asked and answered. She just said it was in the notes turned over on Sunday.
Now, this is a different question. This is specific to the notes on the report, so overruled.
Go ahead, doctor.
so what can you point back to me? What is the question?
Yeah,
that
the
you're
question is,
asking me?
take a look at your notes and the report where you declare him to be insane and schizophrenic. You do not anywhere describe his transfer of value as being 1 point per life, correct?
I believe that he did state that in the drawing that he has made of that it's one life, but I did not write it down in the report as 1 per life.
Instead, you wrote down value of accomplishments and future potential.
Yeah,
Okay, thank you. And then you wrote down that he now realizes that, quote, this was crazy, end quote. Do you see that?
yes.
And the way you described it with Mr. King yesterday was that now he knows that other people think it's crazy, but he still believes it. Do you recall that exchange?
Correct.
That is not what your sentence reads in the report where you found him insane. Fair?
It was his response to my question, further probing, is that what do other people think about that? And he said he realizes that other people will think that this was crazy. He still holds on to those beliefs.
Doctor, do you think that your report says he now realizes that other people will think this was
That
crazy?
this was crazy in the eyes of other people.
That is not what your report says.
This is what it means. I mean, it's a brief sentence. He now realizes that this was crazy, that the perception of other people of what he has done was crazy. He still holds on to those beliefs.
Doctor, you agree that the paragraph that punctuates there at the end has nothing to do with the perceptions of other people. It is his perceptions of why he did what he did. You agree with that?
Asked and answered.
Overruled?
Go ahead, doctor.
The sentence before, or with the context, the few sentences before were related to the self-value, to his delusions, that he will rise by incorporating the value and accomplishment of other people. And my response was, what will other people think about it? My pushing on him was, what do other people think about it? Is this something that other people do to increase their value? People are depressed, people are desperate in the way he was describing himself. And he realizes that this was crazy in my eyes and in the eyes of other people, in the eye of anybody who will follow his belief system that to improve someone's self-value, you kill people.
Doctor, you would agree with me that that entire couple paragraphs of exchange that you had explaining that is absolutely absent from any note or your report from June of 2013. Do you agree with that?
I agree that my notes are brief and the response is brief. And when you ask me to elaborate, I provide you with the context and the details to the best of my ability.
So when you wrote the phrase that's actually in here, the one you knew would be going to attorneys and the judge and potentially the jury, it reads, he believed that his
Judge,
low
I'm gonna
self-value...
object. May we approach?
Okay. All right, the objection is overruled. But Mr. Bruckler, you should proceed as we discussed at the bench. Why don't you repeat your question?
I will, Your Honor. Thank you. The quote, as it is written in your report, that you knew when you wrote it would be considered by people like in this room, correct? You agree with that?
Yes?
Reads, he believed that his low self-value will rise by incorporating the value of accomplishments and future potential of the people he will kill. He now realizes that this was crazy, correct?
This is what it reads.
And anybody reading that would conclude that he now believes that prior statement about his belief was crazy. You'd agree with that?
Objection calls for speculation.
Overruled.
Go ahead, ma'am. You agree that's the way it reads?
What you read correctly. But what I add to it is that probing him and asking him, what will other people think about it? Other people will think that this was crazy. He realizes that other people think that this was crazy behavior. Does he accept that? Based on the evaluation and further information, he still adheres to the same beliefs, the same delusion.
Doctor, do you agree then that looking at it now as we are and reading it the way you wrote it, that it is now, in your opinion, misleading to what you actually intended it to be?
I'm going to object to the question as argumentative.
Overruled.
Go ahead, Doctor. Do you think it is misleading in the way it is written?
Oh, I will not call it misleading. I will call it that it provided information that when somebody reads it without additional information on the context, might conclude that Mr. Holmes was sitting with me and considering all components of what he has done and was saying, you know, what I did is really crazy.
Understood.
It's a little bit different, but I can understand. I don't see it as misleading on my part. Maybe not explaining sufficiently, being brief, yes, but not misleading. I do not intend to mislead the court.
Okay. There's another section here where you say, his nihilistic delusions that the world was coming to an end became bizarre as he came to believe that he was commanded to act and that others would be grateful to him for helping them die before the inevitable catastrophe. Do you see that?
Are we on the next page?
Maybe, ma'am. I'm sorry.
Is it Wait, I'll find it.
It's part of your conclusion, I believe.
Yeah, I remember it.
Yeah, it's part of your conclusion.
I remember the words. So,
13, ma'am?
13?
Yes, ma'am.
I found it.
Okay.
Fourth line from the bottom.
Thank you. Now, tell us, when you explored with him, what was how you characterize it, the inevitable catastrophe?
The world coming to an end, not in apocalyptic terms. He did not use the word catastrophe. I used it.
Why did you use it?
The world coming to an end is catastrophic.
How is the world going to come to an end?
He didn't know the world will come to an end, but he believed that the world is going to come to an end, that life equals death, and that there's no purpose for the world to continue, and the world is going to come to an end. That's part of his nihilistic delusion, that the world is going to come to an end.
Did he tell you when?
What?
Did he tell you when this inevitable catastrophe was going to happen?
There was no date on it, no.
Did you ask him?
Yes, but there was no specific date. It was not, it's going to come to an end on, June 20 or, no.
You'd agree
he
that...
does it as a pervasive sense that the world is coming to an end. And with this, the associated firm and fixated belief that everybody is going to die, life is worthless, and other people are going to die too. I called it catastrophe. He did not use the word catastrophe. It's not in quotation.
You'd agree, too, that he does not repeat that nihilistic delusion of a catastrophe or the world coming to an end to any other mental health provider you're aware of. Correct?
I believe...
Objection, misstatement of the evidence.
Go ahead, doctor. You don't remember him telling that to anyone else?
Yeah, I think that he is talking about the end of the world.
To who?
I can't tell you specifically, but he is talking about that his life is meaningless and that the world will come to an end.
You believe he told one of the other psychiatrists we've heard from that the world was going to come to an end?
I say it's possible. I don't remember, but definitely repeated it to me multiple times, and it was part of his delusions.
You also wrote down that he did not believe that his perception that he was causing no real damage to the people he killed. He fully believed that the victims were not substantively harmed because they were bound to die anyway, correct?
Yes.
But to be clear, there was no point at which he did not know that he was taking their lives, correct?
He knew that he was killing people.
He never thought he was shooting demons or just wounding people. He was intending to kill and knew he was engaged in killing behavior. Is that fair?
Objection, that question evades the province of the jury.
Rephrase the question.
Doctor, you would agree that he had the capacity to know that he was killing people and that he had the capacity to intend to kill those people, correct?
No.
Okay. Now, one of the things you told us earlier was that in your May 2nd, 2013 visit, you went over the Gmail chat that he had with Miss Dada. Do you recall that?
Let me check the date. Yes.
Okay, can you look in your notes and tell us where you indicate that you had a conversation with him about that Gmail chat? Or if you think it's in your report, I'll take that.
I believe if this is what you're referring to, at the bottom of page 6, if that's what you're referring to, once verbalized homicidal ideation to ex-girlfriend and psychiatrist, he knew he had to act, call for action, no way out.
Now, that's it. That's fair. That is what you believe is your reference to having reviewed the Gmail chat with him in detail, is the phrase, once verbalized homicidal ideation to ex-girlfriend. Is that fair?
Judge,
Yeah.
I'm going to object to the form of the question is that is what you believe.
Go ahead, doctor. Is
And
that right?
also, that there, and also on my notes of August 5th, 2014.
No, doctor, I'm only asking you about May of 2013, before you declared him insane and schizophrenic. Your singular reference to what you believe is the Gmail chat is this once, in notes, once verbalized homicidal ideation to ex-girlfriend. Fair?
Yes,
And psychiatrist.
Yes.
Correct? There is no other discussion that you have with him about the language that he used or any other parts of that G-chat, correct?
no other, yes,
In fact, the phrase human capital doesn't show up in there anywhere, does it?
yes,
And the phrase that you used wasn't he G-chatted his girlfriend, it was verbalized, right?
yeah.
No other exploration of that Gmail chat with him prior to you declaring him insane and schizophrenic in June of 2013.
No, I did explore it with him, but if you ask me, did I document here in my writing, the answer is no. Same as I replied previously, but I did explore it with him before my report.
But it doesn't appear anywhere.
Correct.
Okay. You also indicated in May of 2013 that he told you he had no plans to flee. You recall that?
That's what he said.
Now, you explored with him all the steps he took to cover his tracks to set himself up to flee. You agree with that?
Yes,
That appears nowhere in your report or your notes prior to declaring him insane or schizophrenic, right?
was taken into consideration. It's not in my notes.
Taken into consideration?
The fact that he had studs, that he had with him in the car, didn't use, yes.
What else? Did he have cash on him? Do you have money?
I believe he did, but I don't remember how much money. I believe he did.
Do you, one of the other things you don't explore with him, and again, maybe I should rephrase that. One of the things you don't document ever discussing with him at all is why he stopped shooting in the theater.
I did. He jammed.
That doesn't appear in any notes or report either, does it?
Yeah, it's documented.
Where?
Not in mine, but it's documented in the evidence that is available.
But this is a conversation that you had with him?
Yes,
Does it feel like to you, doctor, that had this been videotaped, we wouldn't have all these questions?
Into we having these questions.
Sustained.
Do you feel like a lot of these questions would have been easier to answer if this thing had been videotaped?
perhaps I think that there would have been other action, other questions. You're not clear, your accent is not clear, can you repeat this word or that word? And that's the nature of the legal process, for you to ask me all the questions so that we can present to the court the entire, both sides of the story. I think you'd have had other questions for me.
Thank you. One of the things, though, is that you, even though you had this exchange with him about not fleeing, the only thing that makes it into your report is his claim that he did not intend to flee, correct?
Correct. I'm summarizing what he told me, that
That's right.
he did not intend to flee.
And you are not documenting in there any evidence that corroborates or contradicts any of his statements that he gave to you in that report, correct? Correct?
Correct. Knowing that it is available to the court. I mean, you're not going to take what I say without all the entire story of what happened, all the evidence that is available that I've reviewed. This was his response to me. Did I believe that? No, I did not, because I knew about everything else that happened at that time that is available. I mean, it's part of the record. So I did not repeat it.
In these notes that we received from the notebook that you gave to us, or you turned over on Sunday past, on page 31, do you see that? There's notes you take as you go through certain things with him from the notebook? Do you see that?
Let me find the page, just 1 second. Page 29. Yes.
And you're taking these notes inside this copy of the notebook contemporaneous with your conversations with the defendant, I presume.
Yes.
And what he tells you is killing others is not fair to them.
Correct.
He tells you that he doesn't think he could have gone through with this if he knew the people that he was killing, correct?
Correct.
Even if it was going to do them a favor too, correct?
Correct.
He also tells you that he knows that life is priceless.
Correct.
And I don't know if I can read it, but the other part he told you is if he had found some value in his own life or purpose, then he would not have followed through with this. Do you recall that?
I'm looking for it.
Yeah, I'm looking for the notes too.
It will not make sense to kill if life was priceless. You mean?
Yeah,
In the
yeah.
symbols of
That's what he told you?
in the symbols of infinity is priceless, infinity, the eighth, this symbol that life is priceless.
Thank you.
0, life is nothing.
Thank you.
And then the mission, arbitrary value, if kill one, it is one. This is when it specifically stated that one is one.
You write down there, he tells you if life was meaningful, it would be priceless and it would not make sense to kill, correct?
Correct. And also just, I might have omitted it if I may go back. It tells me if kills one, then one can increase meaningfulness by killing, by kill. And this is the sign of one. A value of one increases his life by one. So it's 1 to 1. I go back to the question that you asked me before.
Yes, I understand.
You showed me this.
Doctor, he didn't tell you that until you sat down with him with the notebook many months after you generated your June 2013 report, correct?
Objection,
No.
misstates the testimony.
Overruled.
Go ahead, doctor.
I'm checking my date, please.
Sure. Look for November of 2013.
Okay, I got the the notebook on February 13, 2013, and on May 2nd visit, I began to go over it with him in more detail, and yeah.
Doctor, nowhere in your notes, nowhere in the report, do you indicate that you went over the notebook with the defendant, correct?
It is indicated, I believe. Let me check, please.
Sure.
Okay. May I address the question
Yes, ma'am.
that you raised?
Yep.
I began to go over it with him and putting my notes down. I followed up on, as indicated in my notes, I didn't do it at one time. I followed up on November 18th visit, and it's written in my note. He was cooperative and examined with me the notebook as I was sitting next to him.
Doctor, you are reading from a note from November of 2013, correct?
Yeah.
There's no detailed laying out of the notebook that you went through with him prior to that, correct?
I went over the notes. As I said, I started going over the notebook, and at that time I was sitting on the other side of the table from him and handed him a page by page. That was awkward. So on the next visit, I sat next to him, asked permission to sit next to him, and we sat together, and I put it there, and that's why I documented it. But I started going over it before my report.
But not documented in your report or the notes, correct?
Correct.
Now, there's a couple things I want to ask you about that report that you generated with the things that we've discussed. Now, inside the notebook, you probably noticed that the defendant uses the phrase or word murder or murderer a number of times. Do you recall that?
Yes.
Do you know how many times he uses it?
I didn't count.
8. Do you agree with that, or you don't
I
disagree?
mean, I trust you.
Do you know how many times you used the term murder in your notes or writing your report before you declared him insane or schizophrenic?
I don't believe I used the word murder.
Correct. Used it 0 times. And you don't disagree with that, right? Correct?
Correct.
Inside the notebook, the defendant uses the word hate or hatred 8 times. You don't disagree with that, do you?
I trust you.
Do you know how many times you use the term hate or hatred in your notes or your report?
Objection, irrelevant.
Overruled.
Go ahead, doctor.
I believe, without searching for it, that I did ask him about hatred of people, and he said that he did maybe a couple of times, and he said that there's no hatred. At one time he said maybe a little, but there's no hatred. It was not motivated by hatred, and it was in the context of, did you kill the people because you hate people? And this is something that has come up with others. To me, little was the only thing it disclosed. It does not say hatred for humankind to me.
That's what you think you wrote in your report. Is that fair?
Do you have on the page, it can save us time, of where I wrote about it?
Oh, ma'am.
Or what? I did, I know that I used the word that it denied or didn't say it was for hatred, but I don't, let me check.
Mr. Brockler, would this be a good time to take our afternoon break?
Sure, Judge. Yeah.
All right, members of the jury, let's go ahead and take our afternoon
yeah.
break. Please make sure you abide by all my admonishments during the break, and I'll see you back here at 3:30. You okay?
I'm sorry.
It's okay. All right, let's go ahead and take our afternoon break. I'll see everyone back at 3:30. The court will be in recess. Thank you. Please be seated. Back on the record, this is the people of the state of Colorado versus James Egan Holmes, case number 12 CR 1522. The record should reflect that Mr. Holmes is present with his attorneys, and the prosecutors are present as well. Mr. King?
Judge, can we, I was just gonna inquire as to how much longer counsel may have, only because we need to get Dr. Gurr on a plane by the end of business tomorrow, due to a lot of other obligations she had, and I didn't anticipate he would be more than 8 hours of cross-examination. She is here all day tomorrow, but I was just wondering if we should ask the jury if they could stay a little late this afternoon, if Mr. Brockler is gonna be much longer.
What time is our flight tomorrow?
Hold on.
May I answer?
Yes.
So my flight is the 6:30, and the obligation is a family obligation. My son is the first child born, a boy, and with Jewish law, we have a bris. And we have a family that flew from Israel for that. And as a grandma, I'd like to be there.
Okay. All right, so we have today and tomorrow, then most of tomorrow. All right. Mr. Brockler, are you anticipating that that'll be enough time today and most of tomorrow?
It's hard to play Karnak on this one, Judge. I will tell the court, by my count, I think I've been able to do about 4.5 hours of purported cross-examination. I have some left. I'd like to be done before the end of today, but as the court knows, that is not entirely up to me.
All right. Okay, well, we'll do the best we can. If Mr. Brockler gets done by the end of today, then Mr. King, you can do your redirect tomorrow, and then any recross can take place tomorrow as well.
Yes, if he's gonna be done by the close of business today, I think we're gonna be fine.
Well, yeah, we should be. Okay,
I appreciate it.
okay. Let's bring the jury in, please. Please be seated, everyone. The record should reflect that the jury is back in the courtroom. Welcome back, folks. Dr. Gurr, I remind you that you're still under oath. Mr. Brockler, you may proceed with the rest of your cross-examination.
Thank you, Your Honor. Dr. Gurr, I'd like to do a little bit of finishing up, and I'll do it in a different way, and maybe that'll speed things up. You did not, in your report, include the use of the term evil, either in your notes or your report. Is that fair?
I believe I didn't.
Did not, correct?
Yeah,
And you also did not use the phrases justice or injustice in your report or your notes. You agree with that?
But objection, relevance, Judge, as to putting
Overruled.
random words in a report.
Overruled. I'll give you a chance to redirect on that, Mr. King. Overruled.
Agreed.
yes,
You did not use the phrase serial murder or serial killing in your notes or your report.
Same objection.
Same ruling.
Go ahead.
yes,
And you did not use the phrase mass murder or mass murderer in your report or your notes, correct?
yes,
Those are all phrases that appear more than once in the notebook. You'd agree with that?
yes,
You'd also agree that nowhere in the notebook is there any reference to a shadow, and I just used air quotes for that. You'd agree with that?
yes,
Now I want to do a little bit of, I'm going to call it a lightning round, Doctor, and what I want to do is I want to go through things that I cannot tell from your report or notes if you covered before you opined in June of 2013 that the defendant was insane and schizophrenic. And what I want you to do is, as best you can, and I want you to be accurate, so take whatever time you need, is I want you to tell me either no, I didn't inquire about that, or yes, I inquired about it, but I didn't put it in my notes or my report, or I think it's in there, something like that, okay?
yes,
Is that fair?
yes,
First thing, the defendant researching making bombs,
inquired,
but not in your notes or your report.
correct,
The way he set up his apartment to explode, catch on fire, whatever term you want,
inquired, not in the report,
and not in the notes.
correct. I think the word, just 1 second,
Sure.
just to look at the date.
Go right ahead. And I'm talking
Okay.
again about your June of 2013
Yes.
report, not the stuff you did right before jury selection.
Judge, I'm going to object to that characterization. Right before jury selection. It's irrelevant.
All right, sustained.
Correct, it's after, it's my notes after the report.
So you did not inquire about it before you issued your opinion about his sanity and schizophrenia.
I inquired, but it is not in my notes on the report.
You didn't document it.
I did not document, correct.
His efforts to gather intelligence on which theaters would be best for him killing the most people.
Inquired, not in my notes of the report up to June.
Why he chose the individual weapons that he chose.
Inquired, not in the report.
Why he chose the specific body armor that he chose.
Discussed, but not in the report.
Or your notes.
Or my notes, correct.
Texts with Hillary Allen.
Asked and answered.
I think that has been asked and answered, so I'll sustain the objection.
The selfies that he took. Do you know what I mean by selfies? Forgive me. The pictures he took
Yeah,
of him.
I know what is selfie.
Okay, I'm sorry. I had to have it explained to me, so. You did not inquire about that before you issued your opinion, or you inquired about it, but just didn't document any of that in your report or your notes.
Just 1 second, because I put the times for myself
Okay.
on the pictures and I'm looking. Just 1 second. Please bear with me for 1 minute.
Yes,
I
doctor.
want to check.
Yes, doctor.
I don't think it's documented for looking at it briefly.
Now, does that
before.
mean that you didn't ask him about it, or you did, but you just didn't document it?
I did and did not document.
Now, do you know what he was going to do with those selfies, doctor?
I know I even wrote the words for it, but to show the selfies, so that other can see the ease of obtaining weapons. The selfies were with weapon, with him with weapons.
You document that in a much later interview with him, but you don't have any documentation of that from before you issued your opinion on sanity?
I have no documentation, but I discussed it. Most of the things I discussed it with him more than once.
Was he going to upload it to the New York Times?
Yes,
Okay, and that's not documented anywhere?
correct.
How about an exploration with him about what he was going to do with squarespace.com _ classic Jimbo?
Not documented
But you did talk to him about it.
briefly.
There's nothing in any of your notes or your report finding him insane and schizophrenic about the phone call that he made to CU Health right before he went into the theater to start shooting people. Correct?
Not in the report, but discussed.
And not in the notes.
Not in the notes, correct.
And not testified to yesterday. Right.
I don't recall, but if you checked, I take your word for it.
There's nothing in your notes or your report about how he felt shooting a 6-year-old girl 4 times.
Objection, Your Honor. Calls for speculation.
Overruled.
Doctor?
No, my not.
Now, no, as in, I talked to him about killing a girl and what he thought about it, but it didn't make it into my notes and my report? Or I didn't bring it up with him before June of 2013?
I did talk to him before, and this was part of him getting emotional. I think it is about discussing killing the families, but I did not go into children. Also, I did not go into the children specifically.
So you didn't go into it with him, or you didn't go into it specifically in your report or your notes?
In the reports, on the notes.
But you recall now going through with him, killing a child.
Yes.
How about the black contact lenses he purchased?
Not in my notes.
But you definitely went through
I
with him.
spoke to him,
Yeah,
yes.
and it's not in your report either, right?
Correct.
How about why he shot at people trying to flee the theater? Well, first off, let me ask you, did he shoot at people trying to flee the theater?
He did.
Yeah, and these are the people that he thought he was doing a favor for, correct? Correct?
Part of the time, the way he expressed it, yes.
And the way he talked to you about it was that he thought they all believed the way he did, right?
Correct.
Did he tell you, or did you inquire with him, why are people fleeing from you from this favor, and why are you shooting at them to keep them from fleeing?
I raised it, but there was no specific details or response for him for why he continued shooting. He shot as long as he could.
And I'm not talking about the length of the shooting. I'm talking about him specifically targeting people who were trying to get away. Did you talk to him about that?
Yes, but there was no specific answer. It was part of the mission of killing people in the theater.
Not documented anywhere, right?
Why he went to the theater to kill people?
No, Doctor, why he targeted people trying to get away from him.
Correct.
Why he needed tear gas. Did you explore that with him?
Yeah, he didn't use the tear gas, I think.
He did not use the tear gas. That's your recollection?
I'm trying to remember if he used it before, at the beginning, but he purchased the tear gas in order as part of completing his mission, to achieve his mission.
What was the tear gas for?
For the people, I believe, but I don't remember the details of that.
When you talked to him about why he purchased the tear gas, and you said for the people, what did he tell you that meant? For why would he need it for the people?
In order to, I don't remember his words, but I think that the essence of it was that it was a way of, he didn't use the word overwhelming or what, but in order part of his attacking the people.
Did he tell you why he thought they might want to overwhelm him when he was doing something for them that they agreed with?
No,
And none of that is documented anywhere in any of your notes or reports, correct?
correct,
And not just before June of 2013, but ever, correct?
correct.
How often he went to the range?
Yeah, I know. I checked how often he went to the range. He went to the range about 5 times.
No, but again, is that in your report or your notes?
No,
Did
it's
you
in.
just- Go ahead.
It's not in the report or the notes, but I know that he went and I did not put it there.
Did you
Like I
dis-
did not put other items.
I am so sorry, doctor. Did you discuss that with him?
Yes,
How about his need for steel penetrator rounds, bullets? Did you discuss that with him?
Object to need.
Rephrase the question.
Doctor, did you discuss with him why he purchased specifically steel penetrator rounds?
I asked him about each type of ammunition that he got, and I don't recall, the details of what he said, but it was in order to kill people.
But not specifically why steel penetrator rounds versus just regular ball ammunition?
Correct,
And you didn't document that anywhere?
correct.
And not just in the June 2013 report or prior notes, but anywhere ever?
Correct.
You did not discuss with him prior to 2013 his thought process of going through the airport as a potential venue for mass murder?
I did.
Not documented, fair?
I'm not sure if it's I think it is documented, but I'm not sure that it is before my report. But I did discuss with him the airport and why he ruled out the airport and selected a theater. He didn't think he'll be able to get on a plane with this amount of weapons, but why he selected the theater.
So that I'm clear, you recall at some point, sometime, you having a discussion with the defendant about whether he'd be able to get onto an airplane with these weapons and this armor?
If he will be able to get to an airplane, initially his plan was, his thoughts were that what can bring the world to an end might be more of a nuclear effort, like the world will come by bombing it all, but this is not something that is realistic.
And that's why he didn't pursue the airport?
Yes.
Okay. That's not documented, as best you can recall, in any of your notes or the report of June 2013?
I didn't check, but if you say so, I believe it's not.
Okay. And I think we've gone through this a little bit with the fleeing part of it, but I wanted to ask you, prior to the June 2013 opinion on sanity and schizophrenia, did you go through with him any alterations he made to any of the equipment he purchased and why he made those alterations?
I did not.
Now, again, I want to be clear. Is that I went through it with him, but it's not in my report, or that is an area I did not explore with him?
I did not go into the alteration step by step, the way I went into purchasing and when did he purchase and reviewed the pictures in the store where he purchased and the orders where he purchased. I did not go into the upgrade of of weapons with.
And I don't mean upgrade of weapons. I mean, did you go through with him why he took black tape and placed it on the inside of the gas mask to make him less visible through the gas mask?
Objection, misstatement of the evidence.
Rephrase the question without the last part.
Yes, Judge, thank you. Did you go through with him why he took black tape and lined it inside the gas mask through the parts that would otherwise be visible?
He did want to be less visible, and he wanted to be able to see less.
Of what he was doing,
Yes,
which he believed was right.
Objection, Your Honor.
Overruled.
Go ahead. Correct?
can you say it again?
Yeah, he didn't want, according to what you're telling us, he didn't want to be able to see the stuff he was doing, even though he thought what he was doing was right.
He wasn't consider.
Statement of the evidence.
Overruled.
Go ahead.
He wasn't considering right or wrong.
I want to go through with you. Oh yeah, I forgot. I left out a couple of things. One of the other things that you didn't go through in your notes or your report is the cell phone stun gun. Correct?
Correct.
Now, did you have a conversation with him about it?
Briefly, not much detail, just knowing that he had it.
Why'd he get it? What'd he tell you?
I do not recall the details.
Something else that does not appear in your report or your notes is a discussion of the different attempts at interaction with people after he broke up with Gargi Dada. Do you agree with that? Here, let me be specific.
Yes.
Match.com, do you remember that?
Yes,
Now, Match.com was something he signed up for in April of 2012. You agree?
yes,
And he did it because, not withdrawing from society, he was looking to find relationships, correct? Is that right?
yes,
Yeah, and you explored that with him?
yes,
It's not anywhere in your notes or your report. Do you agree?
yes,
In any notes or any report,
correct,
ever, correct?
correct.
Now, not just Match.com, but he also goes a little bit farther and goes into AdultFriendFinder.com. Do you agree?
Yes,
Now, did you sit down and go through with him the different postings that he put that we've entered into evidence with him?
maybe not all of them, but I've questioned him about pornography, viewing pornography from well before the crime, and doing it after the relationship with Gargi was over.
And again, first off, none of that's documented either. You'd agree with that? You're right. What you just said, none of that's documented.
I'm not sure, I'll have to check, but I did discuss it with him.
But this is different. I'm not asking you about pornography. I don't care about pornography. What I'm asking you about is a guy that you've described as withdrawing from society, continuing to reach out to develop relationships. That's what I'm asking you. So, you agree that he started Match.com to reach out for relationships, correct?
He posted on that.
Yes, and he set up a profile in order to get relationships. You'd agree?
Objection, calls for speculation.
Overruled.
And you said you talked to him about it, doctor. Is
Yeah.
that what he told you?
That he posted for it, yes,
Yeah.
to have relationships.
And
But
that go ahead, doctor.
it
Sorry.
doesn't posting for having relationship and actually developing relationship is a little bit different, especially for him who had difficulty with relationship. Did he desire, did he want to meet somebody to replace Gargi? Yes, he did. It occurred to him. And one of the things that I reported, I believe yesterday, was that if he goes out, what he misses, what he would have liked to do, is play computer games and develop a relationship because it's novel. But so that's how I saw it.
I understand. My point is this, is that you testified that this is a guy who is withdrawing from society. Remember?
Yes,
These are efforts that he's making to try to stay engaged with society. You'd agree with that, correct?
to some extent, yes.
Yeah. And so we have Match.com, yes? adultfriendfinder.com, correct?
Yes.
What other ones?
I don't recall the names. If you say them, I might recognize.
Well, I want to ask you if you would have considered all of the different efforts he made to reach out, even through the internet, to develop social relationships. Would you have considered those?
Yes.
And you would agree that any reasonable mental health professional in your position that's trying to evaluate his mental health would have considered his efforts to develop social relationships even after April of 2012, right? You would have considered that, right?
Within the general picture, yeah.
Yeah, and it'd be reasonable for a professional to do that, right?
Yeah,
And other experts like you would have considered that too, correct?
they might.
Your Honor, may I approach the witness?
Yes.
Ma'am, Doctor, I'm handing you what I've marked here as, and that's not true. It has been marked as People's Exhibit 1260 and 1261. Take a look at those. Do you recognize them?
I think that I've seen it briefly, but I can't tell you that this is exactly the one I've seen.
Now, what 1260 and 1261 are part of evidence that you were provided, part of discovery you were provided about Gmail accounts that were set up by the defendant, correct?
Correct.
Objection calls for speculation.
Again, you're asking based on what he said to her.
I'm sorry?
You're asking based on what the defendant said to her.
Yes, Judge.
Is that how you understood the question, ma'am?
No.
Okay. I'll repeat the question.
Well, let me back up a little bit then.
Yes.
Doctor, you, in reviewing your 100,000 pages of discovery that you testified to, you came across these documents, correct?
I've seen it briefly, but I'm saying that I can't recall that this is exactly the pictures that I've seen. There were pictures of people.
And I'm
Yeah.
less concerned with the pictures than with what they are. And what I mean by that is, do you agree that these are...
Objection, Judge, to any testimony about what's on the exhibit before the exhibit's admitted.
These are not admitted yet?
No, sir.
Okay. All right, sustained.
Based on what you see there, are these items similar to what we discussed with Match.com and AdultFriendFinder.com in terms of efforts by the defendant, as you know from speaking with him, of his efforts to
Same
develop...
objection, Your Honor.
Hold on, let him finish his question. Go ahead, finish your question.
his efforts to develop social relationships through the internet. Do you agree with that?
Objection, same objection. She's asking for interpretation of what's in the exhibit. The exhibit's not been admitted.
I'll sustain the objection. You can ask a different question.
Ma'am, you said you've seen these before. Do you remember that?
Yeah.
And you said these are the kinds of things that would reasonably be considered by an expert in trying to determine if someone was developing social relationships, correct?
Objection, that's a misstatement of the testimony.
Sustain.
Are these things that would reasonably be considered by an expert trying to determine if someone was developing social relationships?
Objection as to that purpose beyond the scope of this witness's expertise.
Overruled.
Go ahead, doctor.
So repeat the question.
These are the types of things that an expert in your position would reasonably consider in trying to determine if someone they were evaluating was making efforts to develop social relationships through the internet.
The reason that I'm thinking is that putting in within the context of his state of mind as I evaluated him, this was an effort to cling to normalcy, to do something, rather than somebody who was ready to go out and enjoy and meet people. I mean, people do things, but there's beyond that. There was nothing else that was propelling him to be engaged. He posted it, he tried, but I did not attribute this level of significance to it within the general picture, total picture of him continuing to go to the gym and maintaining some activities and trying to maintain some aspects of his life. I do not consider a person who posts as somebody who is a socially appropriate and engaged and capable in initiating and maintaining relationship. So if you ask me if I see that somebody posts, do I think that this person is, yeah, I mean it might, but within the total picture, I think that this is something that is relatively small.
You would agree that someone's efforts to set up accounts with different relationship building websites like you see in front of you.
Yes.
Objection,
those
Your
are-
Honor. We're talking about the exhibit that has not been admitted.
Overruled. I think she testified about what she was seeing in there and these being postings a moment ago. So the objection now is overruled.
Thank you, Your Honor. You would agree that someone's efforts at setting up these memberships with these relationship developing websites is relevant to an analysis of whether or not they are withdrawing from society. You'd agree with that?
To a limited way.
Yeah, and you actually took those and you asked the defendant about, why are you doing this? Did you ask him that?
I did not take the pictures and show the defendant and ask him what he's doing. No.
You confronted him, though, in general with, hey, you're on 4 or 5 different relationship building websites. What were you hoping to accomplish?
Objection to the characterization of relationship building websites.
Overruled?
Go ahead.
I do not confront people that I interview. I ask them questions, I probe. I'm not an investigator and I'm not a prosecutor. I try to obtain the information to the best of my ability and put it within a context. I did explore with them the component that you are raising and discussing, but I did not check how many websites have you subscribed to and what were you hoping to achieve, and did you put naked women in the website or you didn't put naked women in the look at pictures of naked women in the website. I did not consider that this level of details will provide me with information that will reflect overall of his state of mind at that time.
Let me ask then, Doctor, what did you ask him about regarding these memberships and these websites?
In the context of him describing the difficulties that he was encountering both in school and the termination of his relationship, and how he was spending more time by himself, and he wanted clinging to maintaining more normalcy by continuing activities, paying bills. I did discuss with him other relationships that he might be forming. Why did stopping the relationship with Gargi was so devastating for him? And he did say, I asked him about posting. This was in that context. Posting for potentially looking for new relationships.
And he told you that he was?
That he did post, yeah.
In multiple websites?
Yeah,
correct?
But I did not count the websites.
And then one of the other thing, by the way, none of that appears in any of your notes or reports, correct?
Correct.
But you did it.
Yes.
Right? There's also, do you remember he posts prior to his going to the theater and engaging in that shooting, he posts his, I don't know what the right term is, do you know what I mean, but like a caption, or he changes his banner or his saying or his slogan. Do you know what I'm talking about?
I'm not sure.
Does he change anything on his website prior to going to the theater to shoot people that says, will you visit me in prison?
Objection to mischaracterization of the evidence. His website?
So why don't you rephrase the question?
Forgive me. Did you understand, Doctor, that when I said website, I meant his profile on these various websites? Did you understand that?
Yes.
Okay. He says on these different profiles that he posts, "Will you visit me in prison?"
Yes,
Again, part of our now much subdued lightning round. Did you ask him about that?
yes, I did.
And that too appears nowhere.
Correct.
Did you explore with him the fact that to join these different websites where he can make these profiles and join these, have these memberships, that he created an email account separate from the one that he uses with his family and to make purchases for this crime?
I do not remember.
That would be relevant, wouldn't it?
It might, but I do not remember.
Okay, so you might have gone through it with him, you might not have.
No, I do not remember that I went
Okay.
with that through him. We went over the website, but I do not remember. I don't
Okay.
remember the details.
Okay. Bless you. And so you then write this report, June 17th, 2013, and you say, hey, based on what I've seen, whether it's in the report or the notes or not, based on what I've seen, what I've uncovered, you say the defendant is schizophrenic and he was insane, correct?
Correct.
Then you don't meet with him again until November of 2013, correct?
Correct.
And in that particular meeting, just to put it in context of the calendar, that meeting doesn't take place until after Dr. Jeffrey Metzner conducts his sanity evaluation and issues his report, correct?
Please bear with me for a minute.
Sure.
I'm checking. Yeah, Metzner is in September, September the 3rd, 2013.
Right. And so you were able to review that 120 page plus report before you came out and talked with the defendant again in November of 2013?
I went through it.
Yep. Then you came out in November of 2013, and the notes you've provided for that are about a page and a half, page and 2/3. Would you agree?
Correct.
And you don't generate a report after that.
Correct.
How come?
I didn't generate a report after every visit. I continued to see him as much as possible and was not asked to generate another report.
Not asked by the defense to generate a report, correct?
Correct.
Now, you then see him after November 2013. You go and see him 9 months later on August the 5th, 2014, correct?
Correct.
And that is after Dr. William Reed has conducted some 15 plus hours of videotaped interviews with the defendant, correct?
I take your word for it. I don't,
Well, how about this? It was after, certainly after, Dr. Metzner called you and had a
Right.
conversation,
They
right?
called me on August 13.
And it was after Dr. Reed called you and had a conversation with you, correct?
Correct.
And then you went out and visited with the defendant in August 5th of 2014, correct?
Correct.
And you did not generate a report at that time either.
Correct.
But during that particular interview that is just notes, the defendant indicated to you that he had given some thought to fleeing, specifically driving to the airport or driving away, correct?
Yeah, that's the time on about the airport that you asked me before. Yes.
He also told you that at the time that he was planning this and purchasing the body armor, he did all that because, he bought the protective gear because he was concerned about the police shooting him, right?
Yes.
And he did not want to die. Correct? I think it's on page 5 of your notes, Doctor.
Let me turn to page 5, please.
Sure.
Can you please let me know, to just save time, where
Yep,
you
sure.
are?
Sorry. I have.
Page 5?
Sorry. I have down that it's part of the notes that begin possibility he might die when making plans, will get shot by police, got protective gear, didn't want to die.
Yes, in case he's shot.
Correct. Now, on that next page at the top towards your notes, he tells you that he didn't consider that killing other people or wounding them will cause them pain.
Correct.
Correct?
Correct.
But he also told you, didn't he, that he took Vicodin an hour before he went to the theater, correct?
Yes.
Because he didn't want to experience pain as a result of police contact, correct?
Yes.
All right, now, one of the things that you did finally in August of 2014 was to go over the defendant's jail writings. Do you see that in there? And it's on page 7, Doctor, about halfway down maybe?
Yes.
You see that?
Yes.
That was important because those reflect writings that he made in jail while he was unmedicated, correct?
Correct.
And there's also the notebook, which reflected writings that he made when he was unmedicated, correct?
Correct.
Just before the shooting, right?
Yes.
And the jail writings took place just after the shooting, right?
Correct.
And the reason that's important is because one of the things you want to look at is if there's something called disorganized writing or disorganized thinking or something, right? Disorganized thoughts and speech.
Yes.
You would agree that disorganized thoughts and speech involve an inability to organize thoughts, connect them logically, and express them coherently, correct?
Yes.
In fact, that is the most prominent symptom of schizophrenia, in your opinion.
It's one of the prominent symptoms in chronic people with the advanced form of the disorder, not early in the course of schizophrenia, much less prominent.
And again, Doctor, I'm sorry, I'm going to read you this sentence. The disordered thoughts and speech that result are prominent symptoms of schizophrenia. Some would say the most prominent ones. Do you agree with that? And I can show you, it's out of your book.
They can be, yeah.
Okay. And that what it says is, the person may stop speaking abruptly in mid-thought, correct?
Yes.
Respond to questions with answers that are unrelated, correct?
Yes.
Make up unintelligible words, correct?
Correct.
And the person's speech may become so garbled that it's nearly incomprehensible to other people. You'd agree with that, right?
In extreme cases, yes.
Now, in looking at that notebook that the jury has all seen, you'd agree with me that that thing, without getting in the substance, is intentionally organized. Correct?
Within the delusional system, it is.
I understand what you're saying. I just am asking if you agree with me that the structure of the notebook is such that it is organized. You agree with that?
If you look, may I answer?
I hope so. Yep. Please.
If you look at the organization of this book, produced by a first-year graduate student at the university here with an IQ of close to 130, I will say that this is not something that you expect from a person who does have capacity to express and to follow and comprehend what's surrounding him. So, these are the questions that this highly intelligent person is posing. What is the meaning of life? What is the meaning of death? Next page.
Doctor.
Insight into
doctor.
the mind of madness.
Doctor.
This is
Doctor.
not organized.
Doctor.
Hold on. Doctor, you gotta wait for the question, okay? And you gotta answer the question. All right, ask your question.
Thank you. Doctor, we'll go through this, but we'll do it in response to questions, okay? Agreed?
Sure.
Okay, so on page 27, there's something that he captions, insights into the mind of madness, correct?
Yes.
And in that section, he goes through what appears to be his evaluation of the value of life, and, well, that's pretty much it, correct?
Yes.
All right, then on the next page, he goes into a discussion of justice, morality, death. You'd agree with that?
Yes.
Then he goes on to page 30 to alternatives to death, correct?
Yes.
And he numbers pretty clearly the alternatives to death. 1, 2, 3, 4, correct?
Correct.
And then he goes through a brief description that leads to the top of page 31, correct?
Correct.
And prior to page 31, other than his mathematical formula that he goes through with the people, well, in fact, the whole notebook, you'd agree with me, there are no grammatical errors in this notebook.
No grammar. Agree.
You would agree that with minor exception, every word is spelled correctly.
Correct.
Every word is legible, correct?
Yes.
There are no sentences that just stop or drop off, correct?
Correct.
Now, on page 31, he goes into a section called Self-Diagnosis of the Broken Mind, correct?
Correct.
And in fact, everything below there is an attempt by him to self-diagnose, correct? Bless you. Correct?
Yeah, a list of diagnoses.
That's right. And as you know from talking to him, that's a list of diagnoses he tried to research online.
Correct.
Right? The next page is symptoms attributed to self-diagnosis. You see that?
Correct.
And he goes through, in perfect grammar and sentence structure, each of the different things that he thinks may exist for him and describes them in complete sentences. Fair?
Yes.
And he doesn't ever do that in a section separate from self-diagnosis of the broken mind, correct?
Correct.
And he doesn't do it in any section separate from symptoms attributed to diagnosis, to self-diagnosis, correct?
Overall, yes. There's some repetitions, but overall, yes.
Okay, and he does that for several pages, right?
Yes.
Then he draws a line when he's done talking about that subject, right?
Yes.
And he gets into the last escape, mass murder at the movies. Yes?
Yes.
He finishes up with a narrative as to why he is going to embrace the long-standing hatred of mankind, and at the end here, overcome all fear in certain death, and then he makes that symbol, correct?
Correct.
Then the next page is something he calls crazy concepts, right?
What page are you on?
37,
yes.
ma'am?
37.
Yep.
Yes.
And you know from his conversations with other mental health providers that he didn't intend those to be crazy as insane concepts, just way out there concepts that he wanted to talk about. Do you recall that?
Yes.
Okay, and under that, he lists with a word and a line things like futility, yes?
Yes.
And he then goes to Homo sapiens, correct?
Yes.
And he lays out the different views of Homo sapiens through mythical biblical, mythical Greek, and mythical German, correct?
Yes.
Then he moves on from that topic to something called nothing, right?
Yes.
And he gets philosophical there, correct?
Yes.
And then he continues this process throughout the next couple pages, including topics like everything, yes, on page
Yes.
39. Bless you. The ripple butterfly effect, yes? And in fact, when he captions a paragraph or a section, all the writings that fall below it are related to just that topic, correct?
Yes.
Even on page, let's go 40 through 47. Those are all the pages where he writes the word why. Do you see that?
Yes.
Even in those pages, he writes from left to right, correct?
Yes.
On a line, correct?
Yes.
All the way across the page, yep.
Yeah.
And he does that for several pages, correct?
Yeah.
And in fact, towards the end here, he starts writing the word a little bit bigger, so he's writing less words per page, correct?
Yeah.
You never see him write why like in the margins or on the cover or just in a weird place anywhere else in that notebook, correct?
Correct.
Then he has a separate section called Case the Place. Do you see that?
Yeah.
And he goes through a rather detailed, and I'm going to use the word organized, analysis of targets. Do you see that?
Yes.
And he underlines the area that he wants to talk about, correct?
Yes.
And then he goes into a description weighing the pros and cons of each of those areas, yes?
Yes.
Then we get to, once he resolves, by the way, that he is going to do this at the Century 16 Theater, the next several pages involve him going through the theaters that provide the greatest opportunity for him to kill the most people.
Object to the form of the question. It began with once he resolves to do something. I don't think that's written in the notebook anywhere.
Sustained.
Doctor, you would agree with me that there is a portion of page 48 and 49 where it appears that he concludes, and I'll read it, what better place to case than that of an inconspicuous entertainment facility? Do you see that?
You're on page.
49, ma'am.
Okay. Yes.
And in fact, right above it, it identifies that facility as the Cinemark 16, correct?
Yes.
And it appears to you from everything else that follows that he has concluded that this is the place where he'll carry out this crime, correct?
Yes.
So the next several pages are him going through a rather detailed drawing of each of the theaters, followed by the pros and cons of why those theaters would or would not make a good place for him to kill, correct?
Yes.
And some of these cons are related to the fact that it would be too easy for people to flee, correct?
Yes.
And that is where he begins to get into the issue of buying handcuffs, right? Correct?
Yes.
And he assesses that he can use those handcuffs to lock the double doors to keep those people from getting away as he tried to kill them, correct?
Yes.
By the way, and I didn't ask you this back on that last part, but before you opined that he was insane and schizophrenic, did you have a conversation with him about why he bought 2 sets of handcuffs?
Yes.
Not in your report or your notes.
I know.
Is it? Okay. Then, once he does that, on page 52, he
Yeah.
does an analysis of, and spatially sets out where the National Guard is, where the Aurora Police Department is, and where the Cinemark 16 Theater is, correct?
Yes.
And he assesses in there that the ETA, which you understand to be estimated time of arrival, is 3 minutes for someone to come to help, correct?
Yes.
Then he draws a line under that, right?
Yes.
And he stops talking about the location where he's going to commit this crime. Fair?
Yes.
And he then gets into a discussion of something he calls the shrinks, correct?
Yes.
And he actually numbers in chronological order the shrinks that he has seen throughout his life, correct?
Yes.
Yeah. So he puts down Mel, last name unknown, yes?
Yes.
Then it looks like he puts down number 2, Lynn Fenton, correct?
Yes.
But he goes back and realizes I should count Margaret Roth, right? Correct?
He lists Margaret.
Yeah, but it looks, he kind of does it inside a little into
1.5.
1.5. And what he's trying to do there, it looks like, is to make it in order of the people that he saw, correct?
Yes.
And then he goes to number 3, Robert Feinstein, right?
Correct.
Then he follows that up with numbered paragraphs that correspond with those people, describing his interactions with them, yes?
Yes.
and describing his interest in not building a false rapport with them. Yes?
Judge, at this point, I'm going to object. The jury's seen the notebook. It's been published to them. They don't need this witness to just read the notebook. If he has questions about what her analysis of the notebook is, I have no objection to that.
The objection is overruled.
You'd agree with that, correct?
Yes,
And nowhere else, except in those numbered paragraphs corresponding to the numbered list, does he describe any of those individuals. Fair?
yes,
And then he goes all the way through to page 54. He finishes up with embrace the hatred, a dark night rises, and then he draws a line under that, correct?
yes,
And he uses that bottom space for some symbols or drawings, correct?
yes,
And then on page 55, he writes down faith underlined, correct?
yes,
And a question about faith, yes?
yes,
That includes the word murder, yes?
yes,
And then below that, he writes down the word reason, underlined, and then writes down a paragraph about reason, correct?
yes,
And nowhere does he just stop fully analyzing whatever section he just set up, correct?
yes.
Now, I want you to look at the jail writings that were admitted. And, Your Honor, I cannot remember the number of that defense exhibit.
Let's see.
And may I approach the
You may.
thing here?
It's D-TR-94. Thank you.
I do not have a copy with me of the jail writing.
I was worried about that. I think we just admitted it, Doctor, and I thought we were going to publish it. And now I don't know if it's up here. Oh, here we go. May I approach the witness, Your Honor?
Okay.
I'm handing you what's been admitted as D-TR-94. Do you see that?
Yes,
Are those the jail writings?
yes,
Would you agree with me, Doctor, that those writings take place on lined notebook paper?
yes,
And would you agree with me that but for pictures or symbols that are drawn in that exhibit, all the words seem to flow left to right, correct?
yes,
On the lines, correct?
yes,
That punctuation is just as good as it was in the notebook,
yes,
that the handwriting is just as good as it was in the notebook,
yes,
that all the words are spelled just as good as it was in the notebook,
correct,
and that that set of jail writings is also broken down into sections. You'd agree?
yes,
And within those sections, the defendant writes only about those specific sections, correct?
yes,
Nowhere does he just sort of scrawl off into the margin some,
a little bit,
well, but it's part of that section, right? As he's drawing pictures about the game he's setting up, correct?
yeah,
Yes?
yes,
Yeah. And within the context of those jail writings, there are no incomplete sentences.
correct,
There are no made-up words, correct?
correct,
In fact, even in the notebook, I forgot to ask you this, no made-up words, right?
correct,
And part of those writings includes, I'm going off of memory here, at the end, he actually develops a game that he'd like to create, correct?
yes,
And he goes into details about the rules and how people will play, correct?
yes,
Earlier on, he talks about things for galactic colonization.
correct,
And you recall that he was reading books on galactic colonization while in jail,
yes,
and that this was a topic that he liked reading about in his free time.
yes,
Okay. There's something else too. You had talked before yesterday with Mr. King about the defendant but having avolition. Do you recall that?
correct,
I want to read to you your description of it from this book here. It refers to a pervasive lack of initiative and motivation. This is more than just your garden variety trouble getting started on a homework assignment or staying motivated to finish it. Instead, a person with schizophrenia may have trouble planning and finishing almost any task, from school to work to social activities, and includes even basic self-care activities such as eating and bathing. Correct? Do you agree that that is
I agree that this is the description of avolition.
Yep.
And when I might have to go over my words before, but what I described, I believe,
Yeah.
as most pertinent to Mr. Holmes is the flat affect, the restricted affective state he has been in, and not as much, and a little bit of the anhedonia toward the end, but not as much, alogia or avolition. Not every person, I describe negative symptoms and positive symptoms as a background for understanding schizophrenia. I did not say that he suffered from pervasive avolition as far as I remember.
Okay, but then you'd agree with me then that based on that description and what you've just said, he doesn't suffer from that.
At times, the psychotic process is a fluid process. And during this time, when it evolves and emerges, there might be times that there is some degree of symptoms, and these symptoms will not be present to the full extent or to the same degree the following day. That's why we go over it over time. Schizophrenia is not diagnosed at one point, in time after a 1 hour interview with a person.
You'd agree there's no evidence at any time prior to the shooting that the defendant had any issues with self-care, eating, bathing, nothing like that?
Correct.
And that there was nothing pervasive about any lack of initiative on the part of the defendant at any time prior to the shooting on July 2nd? You'd agree with that?
Correct.
There's something else, though, that's from this book that you wrote. And it says, schizophrenia is also associated with cognitive symptoms that involve deficits in thinking abilities, such as making decisions, paying attention, remembering, and then it goes on through some other stuff. You'd agree with that, right?
Yeah, I wrote it.
Okay. And it says examples of cognitive symptoms include problems with absorbing information, interpreting it, and making decisions based upon it. You'd agree with that?
Yes.
Paying attention and shifting focus when appropriate, correct?
Yes.
And keeping recently learned information in mind and using it right away, correct?
Correct.
And you would agree that the level of planning and detail that the defendant went through in first researching and learning about the explosives he would use in his apartment suggests he had the ability to go out with initiative, find this information, absorb it, and put it to use in his apartment. You'd agree with that?
Yes, and I will say within his delusional system.
I understand. You're going to want to add that in, and I'll ask you another question where you can add that in too.
Okay.
He also was able to learn about weapons, which he'd never handled before, correct?
Correct.
Figure out how to purchase them, right?
Yes.
How to find ammunition that would penetrate steel or even the seats in theaters, correct?
Yes.
And that he was able to find a place where he could go shoot at a range, correct?
Yes.
Undetected.
Yes.
And learn how to handle each of the weapons that he would ultimately use to try to kill people in the Century 16 theater.
Yes.
Okay. Now I want to get back to your interviews with the defendant. Now you have already told us you didn't write a report for August the 5th, 2014, despite all of this newly detailed or reported information, correct?
Yes.
In fact, it's in August of 2014 where you first document a conversation with the defendant about the apartment, yes?
The first document, yes.
Yeah. And the handcuffs, right?
Right.
And the selfies, correct?
Yes.
Then, you about 3+ months later, just 2 months before we start jury selection, you go and visit the defendant again, correct?
Yes.
And you sit down with him and have a conversation about certain things, right?
Yes.
This is the meeting at which, and I don't mean he was there, but this is the date at which you are finally able to sit down and have a conversation with his parents about their observations of their son.
Yes.
And his upbringing, correct?
Yes.
And the report that you generated for that ultimately wasn't until February 17th of 2015, some month or so into jury selection, correct?
Judge, object to the characterization that the report was for that The report was for all of the other visitations.
All right, the objection is overruled.
Doctor, based on that, though, I do want to rephrase my question, if the court will permit me.
Go
You,
ahead.
you did not write a report about your interview on November 18th, 2014, did you?
One second.
Yep.
Yeah, this is inadvertently the date, the report, the notes that I did not incorporate in my report. Right.
Right.
I did not note that I've incorporated them, but I did. I did not note, in the first part, I've conducted the additional interview with Mr. Holmes I did not note 11/18/13, but started with 8/5/2014.
Fair to say the report that we're talking about is about a 3.5-page report you generated on February 17th of this year?
Yeah, it's an update, labeled Update Neuropsychiatric Evaluation Report.
And to be fair, too, that update does not include any of the specific information you obtained from November 2013, August 2014, or November 2014. Fair?
It relies on that and all of the information that I've done and I've outlined, that I've gone over, but it is a brief summary.
I understand. On page 6 of your notes from November of 2014, one of the things that the defendant tells you is that he tells you that he told Dr. Fenton that he believed killing people would increase his self-worth. Do you see that? Your notes, page 6?
Can you repeat? Is this from my notes?
Yes, ma'am.
Of November 2014?
Yes, ma'am. Yes,
Okay.
doctor. Page 6, top, sort of.
Can you point me to where in that? I believe it's there, if you say so, but
It's a quote that says, "I told Fenton that killing people will increase my self-worth." You see that?
yeah,
Okay, you see that, right?
yeah, I see that.
That's what he tells you in November of just last year, right?
Correct.
Now, you've had a chance to review all of the reports and the notes from Doctors Fenton and Feinstein, correct?
Yes,
And you know that that doesn't appear in there anywhere, right?
correct.
And also, that statement that he said he told Dr. Fenton that is not consistent with any other statement he's given to any other mental health provider that you're aware of, correct?
Correct.
And it's not consistent either with his stated purpose to everyone, including you, that he wanted to withhold information from them out of fear that they might stop him or lock him up, correct?
Objection to the characterization that made that statement to everyone.
Overruled.
Go ahead, doctor.
So can you repeat, please?
Yeah. That statement is not consistent with any of the other descriptions of his interactions with Doctors Fenton and Feinstein to any other mental health provider, correct?
I do not remember if he said the same thing that he said to me to other mental health providers, but he did say that to me.
Okay. He also tells you on page 8 of your notes, he also describes himself to you in November of 2014 as rationally insane. Correct?
It's the words are familiar. I don't. Yeah, I see it.
Yeah. And
Yes.
that's how he described himself
Yeah.
in November of last year.
It's a quote.
Yeah. And you're aware that he, from the information that was provided here, he actually tried to create a website called Rational Insanity. You aware of that?
Yeah, I don't remember the wording of that.
Okay.
I don't.
You then, 2 lines below that, discuss with him, it looks like it must be the shadows. It doesn't say that, but you said juggling balls or head.
Correct. The shadows.
Yep. And then, right below that, he says that he goes into this description, cloudy shadows, once in a while, a small person or persons juggling balls. You see that?
Yes, this was something that I noted, I think, yesterday, that I went over the same things repeatedly, and that whereas before he did not provide information, did not elaborate, with time he elaborated more with more probing about what are the shadows, describe them more, and it also more specific that it was doing a third lab rotation.
Understood. And so then on page 9, you ask him again about this end of the world stuff, and he says, boy, I just don't remember.
Where is that?
Right above carrying it out, which is underlined.
End of world, don't remember.
Yeah, it says
No,
doesn't remember.
If you look at the line, 2 lines before, were discussing, will it be an apocalyptic event, not by apocalyptic event, to which I responded before when I called it catastrophe. You'll die, it's just death.
But he tells you this in November of 2014.
Correct.
Okay. Then when he talks about, right below carrying it out, he says that in part the movie theater was picked because it was impersonal and there was a high chance of shooting people, correct?
Yeah, right after that, yeah.
Yeah. And doesn't say killing people, just shooting people, right?
Correct.
All right. And then on page 10, you do ask him in November of 2014, or you document that you ask him about the selfie. Do you remember that?
Yes.
And he says to be remembered by whoever views it, correct?
Yes. And the next 3 words say, don't know why. I probed.
Don't know why he wanted to be remembered?
Yes.
Okay. Now, I want to ask you if you'd agree with some things here that I'm going to ask you about based on your understanding of the facts of the case so far and
Yes.
the conversations you've had with the defendant. This process, this planning that took place over 2.5 months, you would not describe the defendant's efforts as one that was committed in a hasty or impulsive manner.
That objection invades the province of the jury.
Overruled.
Go ahead. Correct?
In a compelled manner, not impulsive. He was planning it as documented.
Sure. You believe that he had the capacity to form the conscious objective to kill people.
I believe
It
that
invades the province of the jury.
Capacity? No, overruled.
Go ahead.
I believe that within his pervasive delusional system, all the steps, everything that we have gone through in the galactic colonization and in the notebook are part of his delusional system. And delusional people of high intelligence do have the ability, unfortunately, to plan and execute what is consistent with their delusional beliefs. And that's the essence of his psychosis.
I understand what you're saying. I'm not asking you about the delusion. I'm asking you if you believe, if you would agree, that he had the capacity to form a conscious objective to kill people. And we've been talking about it all day.
Yeah, he had the capacity, and I say within his delusions.
And that he was aware, he had the capacity to be aware that the conduct that he was engaging in would practically certainly kill people.
Judge, this invades the province of the jury.
No, it does not. Overruled. He's asking about capacity. This is precisely what she's opining on.
Go ahead, doctor.
So how do you define capacity? What do you mean? Did he have the ability to order on the computer and to produce all of this? Yes, but it was within a distorted, perception of reality within his delusions. He had the capacity to pursue and follow his delusions. Yes, it has, but at times, if just put just the word capacity, it's like talking about our capacity to sit here and listen and see and write. It's related within the delusion. He had the capacity, and I do not want, and I elaborate because I do not believe that the information that we have reviewed, the lines and the numbering, are meaningful without considering his delusion. A healthy person does not, you have to look at the content of what is there.
Doctor.
So when you say capacity, it assumes that this person, this is totally rational to produce this type of information. And I don't think it is.
Thank you, Doctor, for that. The question I'm asking you, though, is, and we've gone over all of his statements to you about why he wanted to do what he wanted to do, was that you would agree that he has, let's use the word ability.
Ability.
He had the ability to be aware that the conduct he was engaging in was practically certain to lead to the death of others. Yes?
Yes.
Okay. And that he was aware that what he was engaging in, he had the ability to be aware that what he was engaging in created a grave risk of death to others, not himself. Correct?
Judge, this is outside the scope. This is an aggravator.
Would counsel please approach? objection is overruled. Go ahead, Mr. Brockwood.
Can I have one moment, Your Honor?
Yes.
I want to go through with you, if I could, Doctor, just a few things. Well, it's a list of things to get through here. And Doctor, I'm sorry about that. I just want to make sure I ask you, you believe that the defendant had the capacity to knowingly engage in conduct that created a grave risk of death to a person or persons other than himself? Correct?
Can you repeat it again?
Yep. That he had the capacity to knowingly engage in conduct that created a grave risk of death to a person other than himself. Like the people he shot. Correct?
I don't think so.
Okay, thank you. Mr. Holmes, you would agree, appreciated that what he was planning and what he pulled off was against the law. You'd agree with that?
Yes,
And you'd agree that the law, although not in its entirety, is one measure of what society thinks about certain conduct, correct?
yes,
You would recall that the defendant told Dr. Metzner that he knew that killing people was against the law, yeah?
yes,
You also recognize that he said to Dr. Reed, quote, well, I knew that it, meaning the shooting mission, was legally wrong because you get punished for killing people. You recall that?
yes,
And that he told Dr. Reed that he believed the shooting, that after the shooting, he would go to jail or he would die, just like he told you. Correct?
yes,
That in his instant messaging with Gargi Dada on March 25th, 2012, he referred to this interest in shooting people as doing something evil, correct?
yes,
That he also, in that same G-chat with Gargi Dada, said that there's no way to do it, and that's killing people, without getting caught, correct?
yes,
We've already gone through the will you visit me in prison quote, correct?
yes,
You also will recall that in his July 8th, just 12 days before the shooting, really 11 before he sets up his apartment with bombs, he texts Hillary Allen and tells her, in essence, stay away from him, right?
yes,
And you agree that the reason he does that is because, and this is what he told Dr. Reed, I didn't want to hurt her by putting her in jeopardy, being like the girlfriend to a murderer. Do you recall that?
yes,
And the other thing that he ended up saying was he didn't want her to have to endure all of the negative media that would surround what he was going to do, correct?
yes,
That he refused to go into details, bless you, as to the precise nature of his thoughts or his plans with Drs. Fenton and Feinstein because he thought doing so would result in him getting locked up.
yes,
That, bless you, that when Dr. Metzner asked him why he had not previously killed people, given this long-term, more than 10 years obsession to kill, you'd agree with that,
yes,
that he said because of fear of consequences, jail, prison, death penalty, all that stuff, right?
yes,
That when he was confronted by police officers, he put up his hands, quote, to avoid being shot by the police, right?
yes,
You agree that he took extraordinary steps to avoid being detected. Yes?
Yes,
Yeah. And not just in the execution, I mean in the absolute planning of this, correct?
yes,
He, you remember that he said that he made purchases from multiple different stores and through different means, in person and on the internet, to avoid suspicion.
yes,
That in order to combat the possibility that anyone would see what he was doing in his apartment, he closed his blinds.
yes,
That he anticipated the police trying to stop him using lethal force from what he was doing and purchased protective equipment to keep him from getting harmed.
yes,
That's an answer.
Overruled.
That he attempted to divert emergency response teams and police to his apartment so that he could continue to kill people in that theater.
yes,
That he, in setting up his apartment, by the way, he chose real gasoline, yes?
yes,
Real potassium permanganate,
yes,
real glycerin,
yes,
that he used real magnesium.
yes.
Do you know what the magnesium's for?
I don't remember what he said about that.
Do you know what happens to magnesium when it burns?
It explodes.
Well, did he
Can
tell you
explode.
why he chose magnesium?
I don't remember what he said.
Do you, and maybe this will help you remember that once magnesium catches on fire, putting water on it only makes it burn even more, correct?
Yes,
And that it creates, in some cases, a magnesium-based gas, correct?
yes,
That his carpet was saturated in real gas, correct?
yes,
That he used real fuses, yes?
yes,
Real black gunpowder, correct? Real bullets,
yes,
that he made his own thermite,
yes,
and the way he had to make thermite was he actually had to make his own rust to begin with, correct?
yes,
And that the purpose of the thermite was to ignite and burn down into those jars and set off napalm
yes,
that he made,
yes,
causing his apartment to explode,
yes,
and that he had two separate methods of detonation for it, correct?
yes,
That when he spoke with Dr. Reed about his use of the term evil in the G-chat with Miss Dada on the 25th, he told Dr. Reed that killing people is considered evil by everyone. Do you remember that?
yes,
That Dr. Reed asked Mr. Holmes what is morally evil, and he replied something that's against the law, and if you do it, then it's morally evil. You recall that?
yes,
That in the context of killing people that's evil, beyond just being in violation of the law, you'll recall that Mr. Holmes said, quote, if the other person doesn't want to die, that is evil, if you're going against somebody's wishes. You agree with that?
yes,
That he also told Dr. Reed that he believed that the victims did not want to be shot. You recall that?
yes,
And in fact, he told Dr. Woodcock, as we discussed yesterday, he would not have had what he did happen to him. Correct?
yes,
And that in fact, he himself took extraordinary steps not only to not suffer pain, but to survive any confrontation with the law enforcement officers.
Such
Correct.
extraordinary steps, Your Honor.
Sustained.
Ma'am, let me ask you this. Do you think armoring yourself from head to toe, not a single millimeter of flesh exposed to the outside world, is an extraordinary step to protect yourself from the use of lethal force?
Objected, not a single millimeter of flesh exposed.
Overruled.
Go ahead. Would you think that would be an extraordinary step to take?
I'm not sure if extraordinary, but it will be a step that he has taken to protect himself.
Mr. Brockler, how much longer do you think you have?
2 days. I'm kidding, Judge. I'm joking. And that's not even a funny joke anymore. Judge, I would I would guess, this pace is great, 20 minutes.
All right, then I think in that case, we'll probably quit for the day. and then we'll pick up tomorrow, okay? All right, members of the jury, please make sure you follow all my admonishments overnight, and I'll see you back here at the usual time, 8:40 tomorrow morning. Oh, before you leave, I had deferred ruling on Exhibit D-TR-97, which is a video recording, and I have sustained the objection, so that exhibit was not admitted. All right, have a good night. I'll see you tomorrow morning. Thank you.
Hey, you gotta remind me to move to admit these tomorrow. What can I do it right now, or do I have to do it after?
The record should reflect that the jury has exited the courtroom. Everyone may be seated, and doctor, you're free to go. Your subpoena is continued until tomorrow, okay? Thank you. All right, first I have Exhibit D-TR-97. I don't think we need to mark it as a court trial exhibit because we already have two versions of this particular video recording marked as, I believe it's C-TR-78 and C-TR-79. 78 has subheadings or titles, or excuse me, text. 79 does not. And D-TR-97 does not. So the its counterpart really would be C-TR-79. So I'll return it to the defense whenever you want to pick it up. I'll leave it right here. Secondly, in terms of scheduling, it's looking like we're not going to make it by Monday in terms of having closing arguments that day. Mr. Brockler is indicating he still needs about 20 minutes, which in lawyers' lingo means probably 30 to 40 minutes. And then Mr. King, I don't know how long do you think you'll have on redirect? I mean, I don't need you to give me a specific estimate. I'm just trying to gauge. Are we talking about a half a day? Are we talking about an hour, or something closer to an hour, or something closer to a half a day?
I would say 2 or 3 hours, maybe 2 hours.
Okay, so, and then Mr. Brockler may have some recross after that, so that'll take us most of the day tomorrow. The defense still has about 5 hours, I think, of video recording to play, and I don't know if you have any other witnesses. Do you, other than potentially the defendant testifying, at this time, do you know whether you're gonna call any other witnesses?
Potentially one more, Your Honor.
Okay, is that Dr. Gray?
Yes, Your Honor.
Okay, so there's a potential for one more witness. I think it would take us probably through tomorrow, and then if we finish early tomorrow, then we could use the time to finish the Curtis advisement, and perhaps to talk about instructions. And then, do the people still think that they can do the rebuttal case in one day?
I think so, Your Honor. We'll know more after that.
So tomorrow?
Yes, sir.
Okay. That would be great, because I don't want to schedule closings for Tuesday only to bump him again. So if you would let me know tomorrow how long you think your rebuttal is likely to take, then that would be helpful. If you're confident that your rebuttal case can be completed in one day, then we can set Friday for that. Otherwise, and part of Friday and part of Monday, I should say, actually. So, and then we could have closings on Tuesday.
Pretty confident, Your Honor.
In one day? All right, I think what's likely to happen is if Dr. Gurr takes half a day tomorrow, or perhaps even more, the defense will need part of Friday to finish its case. I'm assuming that they'll be able to finish it on Friday. And then if we finish early on Friday, I think I said Thursday before, if we finish early on Friday, then we could use the time to complete the Curtis advisement, finish any discussion about, or pretty much finish any discussion about jury instructions, and then have the prosecution do its rebuttal case on Monday with closing arguments then scheduled for Tuesday. So that only works if you tell me tomorrow that you think you can do your rebuttal case in one day.
We'll tell you tomorrow, Your Honor, for sure.
Okay, great. All right, so we'll just play it by ear, okay? All right, is there anything else at this time on behalf of either party?
No, Your Honor.
No, Ms. Brady's raising her hand from way in the back. Ms. Brady. By the way, before I forget, have we talked about how many attorneys are gonna do closing arguments per side yet? Have the people decided that yet? Has the defense decided that yet?
Your Honor, we're gonna have one.
For both closing and rebuttal close?
Yes, sir.
All right, what about the defense? You gonna have one as well?
Yes, Your Honor.
Okay, all right, and do you need any warnings? Time warnings, I mean.
Yes, Your Honor, I'd like, if the court would permit, two, one at 1:15 and one at 1:30.
Okay, so 1:15 and 1:30, are you anticipating the one at 1:15 will be during your initial closing argument?
I do, Your Honor. I'm trying to figure out a way to save myself approximately 30 to 45 minutes for the rebuttal. Oh, and then, Your Honor, for that rebuttal close, maybe one at 5 minutes till.
Okay, Mr. King, do you know yet?
Can I let you know a little later?
That's fine.
Thank you.
That's okay. I'll tell you the same thing I said before openings, and that is that I think it makes sense for you to exchange demonstrative exhibits that you intend to use, or any exhibits you intend to use, but I'm not gonna require it. That's up to you. I think it saves time. Obviously, if there are admitted exhibits, I don't think you need to let the other side know because they've been admitted, but in terms of demonstrative exhibits, I think it's helpful if you show those exhibits to each other and have that conversation ahead of time. But I won't require it, just as I did not require it before openings. I thought openings went pretty smoothly, in part because you had conferred with each other, but I'll leave it to you. I think there tends to be more interruptions when counsel do not confer, but I'll let you decide how to proceed, okay?
I have one other thing, Your Honor. We've been exchanging on a weekly basis the witness list. We exchanged our witness list with them last Friday evening, and given that all of our witnesses have now been disclosed, I'd ask for a good faith list of potential, non-binding list of potential witnesses for rebuttal from the prosecution, just so we're not caught unawares.
All right. Any objection?
No, sir.
All right, thank you.
Can I ask one other thing about the openings, Judge? And I know the court has, I'm sorry,
That's okay.
I just shuddered thinking about redoing this. Specifically, I know the court had gone through sort of how it wanted to lay out the day in terms of the closings. And respectfully, I'd ask if the court would consider doing it in the manner in which it did the openings, which had the same time hacks associated with it. And the court will recall that we did it all in the afternoon. And my respectful suggestion is, could we offer the jurors the opportunity to have an earlier lunch, come back at noon or noon 30, go through the instructions, and then allow each side the 2 hours with the normal afternoon break after the prosecution's open and close, and then complete the rest of it, and we'd be done by approximately 5 or 5:30. As opposed to, I think initially the court had thought, have the prosecution go in the morning, do the normal hour-and-a-half lunch, and then bring back and come back and finish up.
I think, I thought about that. I think it would be an ambitious plan because of the breaks we have to take and how long I've given you. I think it worked for openings, but I think we went late. But I'm open to that. Is the defense, does the defense have a preference between the two?
I would prefer the way that the court set it out. I think that's we're asking for trouble, that we're not gonna finish in one day then. I mean, when the court says that would be ambitious, I agree with the court.
Yeah, we would have to start no later than probably 11:30 to make it work. I'll think about it. I'm not sure that that's the best way to proceed, but I'll think about it. I'll give it some thought. All right, Ms. Brady?
Just a handful of exhibits that were created on the stand, and we're just
Yes, do you have, would you give those to my staff, please? I'll make sure they copy them for you.
Courtesy copy as well. That, we
Sure.
appreciate that.
You bet. Yep. Ms. Nelson.
Just one other thing. I just wanted to remind the court that I do have a supplemental argument and authority I'd like to make regarding the issue of opening statement at penalty. I certainly don't need to do that now. Maybe at the same time we talk about instructions or something. I'd like to do it at some point, maybe this week, but
Fine.
I just wanted to
Why
remind
don't
the
you
court.
remind me, why don't you remind me when we talk about the courtesy advisement and the instructions, to talk about that as well, please. And are you folks okay with me completing the courtesy advisement, sort of when we're thinking you're gonna be finishing your evidence?
Yes, Your Honor, if you can just give us a heads up when you're thinking about doing that.
Okay.
I mean, when we get closer, perhaps, sir.
Yeah, I mean, it depends if Dr. Gurr is your last witness and then you have the video recordings, we could do it, either after the video recordings are done or as the video recordings, maybe have played in part and maybe the jury goes home a little early, we could do it either way, but it would be around that time. If you call Dr. Gray, then we probably would wait until after his testimony. But my preference would be to either do it sort of at the end of all your evidence having been presented, or as all the evidence except the videos have been published. Does that make sense?
Does, Your Honor, and we don't need a big heads up, just enough time to be able to discuss the matter with Mr. Holmes, so it doesn't come as a surprise.
Okay. Ms. Stitch McGuire, people keep getting up.
I apologize, Your Honor.
All right.
As the court ponders what to do for closing arguments, I was wondering if the court could also entertain how many breaks the court thinks the court might take in between each type of closing argument. For instance, if the court would take a break after the prosecution's initial close, also after then the defense's close, and then also after, well, rebuttal, I guess we're done. But the reason for that, Your Honor, is that there aren't enough seats in the courtroom, as the court knows, for all the victims who want to be here. So I'm trying to figure out how many sets of rotation of victims I can get in to decide who I give the seats to. Thanks.
All right, and we'll have overflow rooms available. Obviously, it's not quite the same, but they'll be available. But I think what I said the other day, and what I still think makes sense, is to have us take a break after I go through the instructions and verdict forms. Then take another break after the prosecution's opening closing argument. Then take another break after the defense's closing. And then, at the end of that would be when the prosecution finishes rebuttal closing. So multiple breaks throughout. All right, thanks everyone. Have a good evening. I'll see you tomorrow. The court will be in recess.